Yes.
My pleasure, Lordship. Lordship, item number 14, Lordship. I am for the petitioner. Unfortunately, I have left my brief, Lordship, today, so another date may be given, Lordship.
You have left your brief?
Lordship. Difficulties to.
No, what do you mean? You have left your brief.
Another date, Lordship. Adjourn for today, Lordship.
Item 14.
14.
You're for the petitioner.
Lordship.
On the request of learned counsel for the petitioner, matter stands adjourned.
Immediate after review, Lordship. Date
To
may
be-
be, Lordship, and otherwise.
To be listed again
21, Lordship.
after vacation.
21, Lordship.
Give a date, please. Perfect.
Published, Lordship. Published. May it please your Lordship. I beg to mention item 3, Lordship. Matter may be taken up after vacation. In the meantime, I will file additional affidavit, Lordship,
Additional affidavit for what?
regarding the submission of detailed particulars before the personnel department.
Okay. Let's wait for Mr. N. Hussain, learned counsel for the petitioner. This is the matter again after the ensuing revocation. So the petitioner may file an additional affidavit incorporating the particulars submitted by him before the personal department for seeking compassionate appointment. Yes.
Published.
May you please, Lordship. Lordship, I beg to mention for listing of on repetition tomorrow, Lordship. Motion, Lordship. The petitioner is not getting pension from the last 6 months, Lordship.
When did you file it? Have you filed it?
Yes,
When?
Friday, Lordship.
Friday. He'll come up. Next week, entire week is motion week. All right.
Kindly to.
No, you take it up with the registry. Take it up with the registry, it'll come up. In case it doesn't come up, you let me know next week. Okay.
May I, Lordship? I'd like to mention for withdrawal, Lordship. For tomorrow, Lordship.
All right.
May I please, your Lordship? I beg to mention item number 18, Lordship. So due to bona fide mistake, step could not taken, Lordship. Today we will going to take step, Lordship.
Cash paid for by the learned counsel for the petitioner. 2 days time is granted for taking steps for service of notice upon the respondents. List again after 3 weeks.
Ladies, item 1 for motion.
My lord, the
May it pleases your Lordship, instruction received, your Lordship. I would like to place it, your Lordship. For 33/2026, your Lordship, Inspector of School, your.
Just a minute.
Proposal has sent. Accountant General, Asa. It will happen. Treasury disseminate. What? So no.
Yes.
My lord, during the pendency, my lord, certain amount has been received. Now, whatever has been received, my lord, we don't know under what heading what has been received and whether there is any pending. So, my lord, that is the amount on such dates, my lord, that 50 lakhs and odd has been received.
Mm.
But whether there is any pending dues and all that we are not aware of. So only that.
Instruction letter.
So we are not aware whether there is anything more to be received, since we have not been received any written communication.
See, the instruction, is it coming? The instruction received by Ms. Pidas is that DCRG and area salary for pension are pending at Darang Treasury and will be released from the same.
GIS.
DCRG and area salary. Otherwise, GIS, leave encashment, benefits,
That has already been sanctioned, your lordship.
mm,
And now your lordship, GPF proposal has already sent to the Accountant General Assam for sanction the same, your lordship.
what is remaining to be given now?
Your lordship, Director of Pension of Assam and the pension case has been finalized by DOP Assam, that is PPO number ADP/PPO GPO 2025 dated on 14/11/2025. However, his DCRG and arrear salary for pension are pending at Dorong Treasury. So now your lordship, Director of Pension can get the fresh instruction, latest instruction. Why it has been pending at Dorong Treasury.
You take a copy of this and get instruction yourself,
I have received one copy, your lordship.
this one.
I have received one copy.
So we don't know what is what here. Amount of 50 lakhs, 51,141 has been received.
Received.
So this includes what are the heads which
Heads.
included and what is remaining, that you find out. Okay, Ms. P. Das, Learned Standing Counsel, Secondary Education, submits that as per the instructions she has received, the GIS leave encashment benefits of the retired headmistress has already been sanctioned. And the proposal for GPF has also been sent to the Accountant General, which was sanctioned by the latter. So further, pension proposal was submitted to the Director of Pensions. And the same has been finalized. Through PPO number ADP/PPO/GPO/2025/K 030684 dated 14/11/2025. Stop. However, DCRG and area salary for pension are pending at Darang Treasury and will be released shortly. Stop. The Learned Standing Counsel submits that the same is the instruction received from the Inspector of Schools, Darang District Circle, Mangaldan. Next para. Mr.
HK Sharma.
H.K. Sharma, Learned Counsel for the petitioner, on the other hand, submits that a total amount has been received. A total amount of rupees 50,51,141 has been received by the petitioner between the period 28 to 2025 to 25 to 2026. But however, no details are available to the petitioner so as to understand under what heads, HEADS, the amounts have been released to her. No, to him. Headmistress is no more?
My lord,
Headmistress, the pensioner,
no, she has died.
she's expired. The husband, this is the husband,
My lord.
to him. A copy of the amount received by the petitioner so far, which has been put in writing, is handed over to Ms. P. Das, Learned Standing Counsel, to enable her to obtain further instructions as to the heads under which the payment has been made so far, and what exactly is the amount which is left, which is still pending to be paid to the petitioner. Let the matter be listed again. When?
So
Immediately after vacation.
after vacation,
Give it. On 27th.
I'm deeply obliged. Item 2. May it pleases your lordship, here your lordship, the contention which I already placed before your lordship, that the petitioner is a brother, your lordship, and living wife and daughter is still alive, your lordship, and they have not claimed any pension benefits. So your lordship, under this circumstance, he cannot apply because wife is alive and your lordship, he has also leaving behind one daughter.
Where is your affidavit?
Your lordship, I will be filing it, your lordship. After
Last time you said you received instructions.
short date may be given, your lordship. I'll filing it, your lordship.
Although time was granted to Ms. P. Das, Learned Standing Counsel, Secondary Education Department, to file affidavit in opposition in terms of the instructions she has received, but the same has not been filed. So she further prays for 2 weeks' time, file the same. Well, prayers allowed, list again also.
I'm deeply obliged. Item 4.
Ma'am,
Yes.
but as per the order dated 16 to 26, my lord, the other side was supposed to take instruction and submit their counter, but that has not been done as of yet.
As per the order dated
My lord, 16 to 26.
16 to 26. But there's no order as such. This is item 4.
My lord, in this matter, my lord, the petitioner was imposed with the penalty with compulsory retirement, my lord. They filed a writ petition, my lord. After filing the writ petition, she preferred an departmental appeal before the chairman CIT, Central Institute of Technology, Kokrajhar. And as per my instruction, my lord, the appeal was decided in favor of me. Now the matter has to be placed before the Board of Governors, and the Board of Governors will convene their meeting after the elections, my lord. So, my lord, my instruction is this, my lord, the matter may be adjourned till June, my lord, so that the Board of Governors will take a decision on the decision made by the appellate authority.
What did you say your case was?
My
With
case-
compulsory retirement.
Compulsory retirement, my lord. I filed a writ petition. After filing the writ petition, my lord, the petitioner preferred an appeal before the chairman CIT, who is the appellate authority. The appeal is decided by the appellate authority in my favor.
All right,
Now the matter will be placed before the Board of Governors.
June. Mr.
RM Decca, my lord.
R.M. Deka, learned counsel for the petitioner, submits that the grievance of the petitioner is with regard to his or her,
Her, my lord.
with regard to her, with regard to she having been compulsorily retired. Stop. He submits that after the filing of the writ petition, the petitioner submitted a representation before the chairman CIP, which was favorably considered. Stop. The next step is that the matter has to be placed before the Board of Governors for approval, for final approval. Stop. However, in view of the ensuing state legislative assembly election, the Board of Governors will be able to sit only after the elections. And therefore, he submits that he has instructions to seek for adjournment till June 2026. In view of above, list this matter. In the
Liberty may kindly be given, my lord, to, I'll make a mention, my lord.
in the second week of June 2026.
Yes,
However, liberty is granted to the petition to make a mention if the Board of Governors has had its sitting prior to the next date.
my lord. Deeply obliged.
Item 5.
Okay. Not in this case, not the other side was supposed to submit their
This is your
count.
case.
Minor,
Are you sure?
minor. This time I'm sure.
The last court date, you said 16/2.
16-2 minor.
Okay.
The question.
The notice has not been issued.
Yes. Really not issued, but even then that plea was raised, my lord, on that occasion. But even then the honorable court was pleased to direct that, yes, since you have entered appearance, no notice is necessary. Better you take the instruction and then accordingly.
So, which time may be granted, we have missed it, we'll file the affidavit. Unless notice is required, notice.
Tell me, what is your case?
My lord,
What is your case?
my lord, I have come before your lordship challenging the, my lord, the issuance of show cause notice, my lord. Because earlier, my lord, a show cause was issued, my lord, and on the same cause of action, my lord, subsequently another show cause was issued. And
So
subsequently,
earlier it was issued.
my lord.
What happened to that show cause?
Well, that I filed my reply, my lord.
Hmm.
So in the meantime, my lord, the second and subsequent show cause was issued, and subsequently, my lord, despite, my lord, I submitted my reply, my lord, departmental proceeding has been issued against me. That too on the same cause of action, and the some action has
Hey,
been.
just a minute, Mr. Counsel.
My lord,
After that first show cause notice was issued to you,
my lord,
you submitted your reply.
my lord.
So no action was taken.
No.
Instead, they issued another,
On both,
just a minute.
my lord,
Instead of taking any steps, they again issued show
My-
cause notice
my lord,
on similar to the first show cause notice.
my lord. Similar means, my lord, the fact is that on 4/4/2025, my lord, show cause was issued. My lord. I replied to that. On 7/4, my lord, the respondents, my lord, from official, some official from the director office, my lord, they visited the college for inquiry with regard to the, my lord, first show cause notice, my lord. And that, although I participated in the inquiry, my lord, dated 7/4/2025, my lord, they brought some allegation that I did not cooperate, and pursuant to that, my lord, some action was taken against me and departmental proceeding has been initiated against me, my lord. So my plea is that, my lord, since I have, my lord, participated in the, replied the first show cause, and even that, my lord, I participated in the inquiry also, cooperated. So second and subsequent show cause was illegal, my lord, and that no action could have been done. That too, my lord, without furnishing any copy to me, my lord. So that is simply my case.
And in the meantime, I have been suspended, my lord.
You are working in which post?
Tutor principal, my lord.
Sorry,
Tutor principal,
tutor principal.
my lord.
Of what kind of school is this?
My lord, college, my lord.
College?
My lord. This is Hamidabad College, my lord.
Hmm. So I think we'll issue notice then.
My lord.
Let them file affidavit.
My lord. My lord.
Heard, Mr.
Yeah, Ali, my lord.
A. Ali, learned counsel for the petitioner who submits that the petitioner is aggrieved with the issuance of second show cause notice, despite having participated in the first show cause notice, along with a reply to the same. Next para, issue notice of motion returnable by 4 weeks. Mr. A.R. Tahibildar, learned selling counsel, higher education, accepts notice on behalf of respondent numbers
1, 2, 3, and 4, Lord.
1, 2, 3, and 4. OSD?
Yes, please.
OSD also you can appear?
Yes.
1 to 5. Petitioner to take steps for service of notice upon respondent numbers 6 and 7 by speed post within 3 days. Extra copies of the writ petition be furnished to Mr. Tahibildar. List again after 4 weeks. Respondents to file their counter affidavit in the meantime.
Can I have a date, my lord?
Give a date.
8/5.
Published.
Item 6.
We have filed this contempt petition against violation of judgment and order dated 2/12/2025, passed in WPC number 564/2020. Lordship will find the judgment at page number 9, your lordship.
How many writ petition? Only one.
Contempt there's 2, your lordship.
No writ petition, only one.
Only one.
And petitioners are
For
Five.
5 in number.
5 in numbers. What was the direction?
Lordship will find it at page number 32, paragraph 42 and 43, your lordship. If I may be permitted to read those. In view of the discussion made herein, I am of the considered view, the impugned decision and order dated 6/5/2020 and 10/6/2020 are unjustified and not sustaining. Accordingly, the impugned decision and order dated 16/5/2020 and 10/6/2020 are hereby set aside and quashed. Consequently, all the orders, including cancellation of the appointment orders, are also set aside. Paragraph 43. As a result, the petitioners are entitled to be reinstated in service as teachers of LP and ME schools in the district of Nalbari in terms of the selection and appointment made pursuant to the advertisement dated 28/12/1996. Accordingly, the respondents are directed to reinstate the petitioners in the services without back wages following the principle of no work, no pay. However, with seniority and other entitlements as may be permissible under the law. The writ petitions are accordingly allowed disposed of. However, no orders. We have submitted the representation, lordship will find it at page number 33, lordship. It's in vernacular, lordship. I've given the translated copies of the same. There was some mistake on our part. We could not annex the same, lordship. I've supplied copy, lordship, and I'll make the necessary corrections in the writ petition.
Heard, Mr.
And got to my lordship.
N. Gautam, learned counsel for the petitioner who submits that the direction passed by this court by judgment and order dated 2/12/2025 in WPC number 5641 of 2020 has not been complied with. Only one respondent.
2, your lordship. Director of Secretary of Elementary Education, lordship, and Director of Elementary Education.
By the respondents, despite a copy of the same having been furnished to them. Issue notice returnable by 4 weeks. Petitioners to take steps for service of notice upon the respondents by speed post within 3 days. List again after 4 weeks.
Lordship, may I be permitted to insert these pages in the contempt petition, lordship? Lordship otherwise does not indicate, Your Lordship, I'll speak to the registry and get it done, Your Lordship.
Hmm?
I'll speak to the registry and get it done, Your Lordship. Insert this page.
Seven.
Yes.
But here in this case,
Hmm.
I was appointed on 23/11/1993. I joined the post on 27/11/93. Now what happened, my lord, my service was regularized on 3/3/96. Thereafter, my lord, I was paid salary. Now, my lord, my grievance before your lordship is this, that my service benefit, that is pension benefit, may be given from the initial joining, my lord, that 27/11/93. But that was refused by impugn order, my lord, that is at page 27.
Second round. This is second round.
Speaking order, my lord, 27.
This is second round. Will issue notice?
Second time. Second.
Yes. Heard Mr. M.A. Sheikh, learned counsel for the petitioner, who submits that this is the second time the petitioner is before this court. The earlier writ petition being WPC number 2423 of 2025 was disposed of by this court by order dated 18/7/2025 with direction to the respondents to consider and dispose of the representation of the petitioner. So pursuant thereto, the Director of Secondary Education has passed speaking order dated 3/9/2025, by which the representation of the petitioner has been rejected. Stop. As such, the petition is again before this court. Next para. The learned counsel submits that the claim of the petitioner is to be given the pensionary benefit with effect from 27/11/1993, on which date he had joined service, instead of 21/10/2020, 21/10/2003, which according to the respondents is the correct date from which the petitioner is entitled for pensionary benefits. Next para, in view of above, issue notice, a motion returnable by 4 weeks. Mr. U. Sharma, learned standing counsel.
For both the respondents.
Secondary education accepts notice on behalf of all the respondents. Stop. As such, no formal notice is required. Petitioner to serve requisite copies to Mr. U. Sharma within 2 days. List again after 4 weeks. Respondents to file their counter affidavit in the meantime.
Item 8.
In this case, my lord, the petitioner is aggrieved by the order dated 6/11/2025 at page 110. Whereby the Secretary of the Higher Education Department had wrote a letter that to verify as to whether any head assistant has been getting excess grade pay. The grade pay of the petitioner was enhanced with effect from 11/2/2023, and after this order was passed on 6/11/25, the Director of Higher Education had written to all the colleges at page 29/12/2025 at 111. And after that, my lord, the Treasury officer at next page at 112 had written to recover from the excess drawing. My lord, we had the similarly situated petitioners have approached this honorable court, whereby this honorable court was pleased to grant interim order at page 121. The connected matter in WPC number 1157 of 26, whereby it was directed that till the returnable date, no further recovery may be made. So as of now, the petitioner is praying that similar order may be passed, my lord, because he is also similarly situated like those petitioners, my lord.
You are still in service
I'm still in service, my lord. My service is till 2028, my lord,
as head assistant.
as head assistant. I'm still in service, my lord.
Where are you serving? Borough College.
No, this is my lord. He is from, earlier he was Madhavdev College, now it is Madhavdev University. But it is covered, the Director of Higher Education will take all the responsibilities, my lord. There is the enactment which provides that the responsibility shall be of the Director of Higher Education. The grade pay which was granted was on 25/8/2017 at page 83, my lord. This was the grade pay of 10,300 rupees, my lord. Now they are trying to reduce that. And in fact, there was letters passed at page 92, whereby the secretary, joint secretary of the higher education has written to the director of higher education at page 92 that to enhance the grade pay. They have themselves enhanced the grade pay and now they are trying to recover from the petitioners, my lord. So in that view of the matter, my lord, my lord had passed an interim order as to why they can try to reduce the grade pay.
Which is the impugn order?
Impugn order, my lord, is at page 110, my lord. 110, 111, and 112.
You've been drawing the,
Grade pay of 10,300 rupees.
since when?
Since 2023, my lord. 11/2/2023. I made the statement, my lord.
No, where is that amount mentioned? 10,000? Grade pay?
Grade pay, my lord.
Where is it mentioned?
Page 63, my lord, may kindly see. '63 and 62. 62 and 63. This is my service book, my lord.
What is your original post?
I had joined as senior assistant. I was promoted as senior assistant on 2017, my lord.
Is it same with supervisory assistant?
Then I was promoted, granted grade pay of, I was promoted to head assistant.
No, senior assistant, is it equivalent to supervisory assistant?
Yes, my lord. What they have done, my lord, supervisory assistant, they have made it as head assistant. And after that, my lord,
You are senior assistant otherwise.
now I'm not head assistant. I'm the head assistant of the
No,
college.
earlier you are,
Earlier I was supervisory assistant, but if my lord may kindly peruse,
no, two things are there. One is head assist, one is supervisory assistant, one is, what do you call that? What assistant you said?
head assistant.
No, not head. Head assistant is after redesignation.
My lord may kindly see page 90. What they have done, this is the order passed by the secretary. They have said that after careful examination, the government of Assam in higher education department is pleased to redesignate head assistant instead of supervisory stroke supervising assistant.
Where is that?
Page 90. They have done the redesignation, man.
So the post name of the post is only redesignated. And according to them, this is without any financial implication that the finance has approved about the redesignation.
But
This is what they say.
they
Isn't
say,
it?
but they are
But you're getting the higher scale. What is the scale of the supervisory assistant? Or grade pay, whichever. Head assistant is getting 10,300 grade pay,
Yes, my lord.
and supervisory assistant will get how much?
It says shows 8,000, but my lord, may kindly also peruse that it was the redesignation done by them, and there are judgments.
I'm not on that.
Yes, my lord.
Just tell me the pay. What is the difference?
Page 83, it shows, my lord, supervisory assistant is 8,000, but head assistant is 10,300.
8,000 and 10,000, 10,300, isn't it?
And they have been paying us 10,300 since 2023 onward.
This is 10,000. How
And
many
my lord-
petitioners? How many petitioners are there?
Here only one petitioner.
Okay.
The other, my lord, may kindly peruse 121, my lord, 121. My lord had passed an interim order, my lord. Similarly situated, my lord.
Well, that you have shown me already.
And there are other cases also at page 127, my lord.
Where is this, Ocha? Please write down. The petitioner was appointed and working as supervisory assistant in Madhav Dev University, Madhav Dev College, which was subsequently renamed as Madhav Dev University, and was given a grade pay of rupees 8,000 per month. Stop. However, with the redesignation of the said post as head assistant, the petitioner came to enjoy the grade pay of rupees 10,300 from
11 to 2023.
11 to 2023. Stop. According to the petitioner, the respondents are now contemplating to withdraw the same. And give him his earlier grade pay. And also at the same time, they are contemplating to recover the excess amount paid to him. Stop. Hence, the petitioner being aggrieved is before this court. Stop. The learned counsel submits that similar other persons have also approached this court, and this court has granted them an interim prayer directing the respondents not to recover from their pay. Stop. He therefore submits that a similar direction will be passed in the instant case. Next, para in view of above, issue notice of motion returnable by 4 weeks. Mr. U. Sharma,
Yes, yeah.
S. Bhuya, learned standing counsel,
Higher education.
higher education accepts
2 and 4.
notice on behalf of respondent numbers
1 and 4.
1, 2, and 4. Who is 3?
3.
Ms. R.M. Barua, learned standing counsel, finance accepts notice on behalf of respondent numbers 3 and 5, 3 and 6. 3, 5, and 6.
7, they have a standing counsel. I will serve him a copy, my lord.
Who is that?
Mr. PJ Pukon.
Petitioner to serve notice to respondent number 7 to their standing counsel, Mr. PJ Pugar. And thereafter submit the acknowledgement receipt to the registry as proof of service. List again after 4 weeks. Respondents to file their counter affidavit in the meantime. Stopping the interim, it is hereby directed that till the next returnable date, the respondent shall not make recovery from the petitioner's pay. List on so and so. Then 5.
Item 9.
Where is lodged?
Mhm.
With limited grievance, lordship, the petitioner is before your lordship. Also, the petitioner lordship sought some information lordship, and accordingly she filed RTI application against the respondent number 5. That lordship will find at page number type copy 12. This was the application under RTI application, and this was filed on 23rd of May 2025.
What is the petitioner?
My petitioner is also assistant teacher lordship
Of a
of Gauhati other high school.
high school,
High school lord.
assistant teacher of high school. What information this she asked for?
In lordship, the regarding against the respondent of 5 who is holding the in chargeship of the school regarding her joining letter, appointment, initial appointment letter that I have lordship stated, and lordship the transfer order.
No information regarding respondent number 5.
Respondent number 5.
Why do you want the information?
Because I came to know that lordship, there is some dispute regarding, there is some lordship doubt regarding her qualification, joining letter, and lordship the appointment letter. Because initially she was appointed as a drop teacher. So when the drop teacher was a provincial in the year 2010 itself, and thereafter she transferred to this present school lordship, and accordingly she
No,
is
for that you approach the authorities. Why the court?
yes, lordship, I initially filed before the authority, director of secondary. Lordship, kindly see page 12, annexure 2, to the public information officer, director of secondary education, Assam. So this was my first application. This was done on 23rd of May 2025. So thereafter, lordship, after expiry of 30 days, lordship, the authority has not provided me the required information, so I filed first appeal. That appeal is at page 13. And when they received this appeal, lordship, what they had did, lordship, the authority, they requested the person concerned, the respondent number 5 herself, to provide the information. That lordship will find at annexure 4, page 14. From the inspector of schools to the headmaster. And this is the respondent number 5, headmaster. Now, in reply, lordship, the headmaster, her lordship, refused to give the information on the plea of exemption, lordship. That is, lordship will find at page 15, annexure 5. So agreed by lordship, the petitioner now filed second appeal, and now that appeal is filed on 19th of August 2025. But this appeal is yet to be disposed of. So I pray for disposal of this second appeal, lordship.
Where is your second appeal?
Page 17, annexure 6.
What is 15?
15 is the reply.
By the respondent number 5.
That's number 5.
For saying what?
Saying that they is exempted.
Okay.
The information what I sought, lordship, these are exempted, lordship, under the RTI. So agreed by this, lordship, I filed this second appeal. Second appeal, annexure 6, page 79. Now this is now pending. So I pray for disposal of this second appeal.
Do they have a standing counsel?
No, lordship, it is the government, lordship.
Yeah, paying for the permission, madam. My lord, here the petitioner has, my lord, no locus to file the writ petition, my lord. Because, my lord, that RTA filed by the husband, my lord, before, my lord.
No, any,
Petitioner has not filed the RTA application, my
no,
lord.
any person.
My lord, page, stand to the page number 13, page number 12 first, my lord. Page number 12, my lord, annex 2, my lord. Name of the applicant, Rupam Saikia.
Yes, to my
And
husband.
the bottom, my lord, our Rupam Saikia signature is there, my lord. Okay. And second page also, my lord, page number 13, my lord. That Rupam Saikia. The bottom, my lord. And
So there is no bar also.
Rupam Saikia is your husband.
Husband, yes, I've stated also. So there is
my
no
lord,
bar.
petitioner
for seeking
has
information.
legal right and fundamental right is not violated. Even it is not come under the public interest, my lord, that petitioner has no loss. Because he is come under 226 million.
That's if the person, the respondent number 5, she is holding the.
Her husband can file petition, my lord, but petitioner cannot file.
Oh, any person also, under the ITI law, any
Because
person can.
if it is the public interest litigation of public interest involved, that question is different.
Yes, she is holding a public office. What my learner page submitted, I don't understand. also.
No, my lord. Well, what is the locus of the petitioner? Because her fundamental right violated, my lord. Her right is not violated, my lord. Application, RT application made by the husband, my lord. Then it is the duty of the husband to file a writ petition, my lord, if he is agreed, my lord.
Also,
The wife has no rule here, my lord.
also under RTI lordship, any person can file an RTI application lordship. It is my, through my husband, I filed this application. Because I know lordship, she will not provide the information.
We are not against the RTA matter. RTA is matter legally filed matter. Husband has right, wife, anybody has right matter. But coming in the writ petition under 226 matter, we have objection because petitioner has no locus. It is
Because
clear
the
matter.
information sought against the respondent of 5, she is holding a public office. They discharging public duty.
The content
And they, lordship, they are supposed to dispose of the appeal within 90 days. And that period is also over. And lordship, kindly see the conduct of the respondent. They lordship transfer the petition to the person who against whom I am sought information. So that is why she refused. So accordingly, lordship, under this ITI, I have the right, lordship. I filed second appeal. And now this is pending before 24th of June 2025. Let them take a call, lordship, on this application, second
My
appeal.
lord, then my lord, one person filed RTA matter, another person came before the honorable court by filing a writ petition. Then that person filed their RTA.
Lordship, anybody can get.
Now I am coming before the honorable.
Lordship, anybody can get the information through RTI.
The 226 matter legal and fundamental right.
Lordship, no
So-
reason to be assigned. Lordship, kindly.
No, see, I understand what you all are saying. Okay, there's no point in arguing on that issue.
Lordship.
What I was trying to ask was, anyone represents respondent number 4?
Respondent of 4,
Do they have a standing counsel?
the government.
I am a paying man.
See, he is a paid.
You are there.
I am a paying.
It is requested by the government.
Commissioner,
My lord.
Assam
Information Commission,
Commission.
Information Commission, you are appearing.
My lord.
I see. So, annexure 6, what has happened to this? You find out?
This is now pending before them.
That is what I'm asking him.
Oh,
He'll
sorry,
find out
sorry.
now.
Sorry.
My lord.
Why it's pending? That's all. Without entering into the nitty-gritty of this, that.
My lord, that instruction I can provide, my lord,
Ah.
from the commission, my lord. But my question is that, my lord, even if petitioner has no locus, my lord, then there's a fruitful exercise, my lord, because petitioner has no right,
No, even if, supposing writ petition is not filed,
my lord,
writ petition not filed, 0, nil,
my lord.
blank slate. Then what happens to this annexure 6?
Definitely, my lord, that.
Is it not your duty to consider this and dispose it this way or that way?
Absolutely, my lord.
So,
That, my lord, I have.
so you find out, I'm not saying anything, you just find out what has happened to this application. That they're under consideration, they're disposing it off, they're still looking at this, something, you find out. Depending on that, we'll take a call.
That instruction I can put, my lord, that,
Ah.
not a problem.
When can you get the instruction? Get it? The grievance of the petitioner is that the second appeal filed by the petitioner
Not by the petitioner, her husband.
filed by the petitioner's husband before the commissioner, Assam Information Commission, bracket respondent number 4 has not been, did I give you the date? On 19/8/2025, bracket annexure 6 has not been considered and disposed of till date. Mr.
Please, again.
P. Soikia, learned government advocate, shall obtain instructions by the next date as to the status of the second appeal. So Mr. P. Soikia, learned government advocate, otherwise submits that the petitioner has no locus standi to file the instant writ petition. And therefore, the writ petition is not maintainable and should be dismissed. Stop be that as it may, depending on the instructions received by him, court may consider the same on the next date.
So to that submission, which I have a suggestion, under section 3,
Hmm.
all the citizens can sought information of the
No,
RTI.
no, I am
Right.
not
No, that will be
against the
recorded.
information, my lord. I am against
Yes.
the petition file under 226.
I have
my lord.
gathered the information through RTI.
You
There
may
is,
be
there
right,
is
my
no
lord.
bar, Lordship.
Information, I have no
Lordship,
objection.
Lordship, that submission will be record, Lordship, because already since he is submitted, that this is
You
not
submit next
maintainable.
day.
So
We are
under
not
section-
disposing of the case.
Lordship,
I am not disposing of the case.
true, Lordship, but see, there is, whether it is maintainable or not, that question raised my learned friend.
That is a
My
submission.
Is that to that effect, Lordship, under section 3 of the RTI Act 2005, all
No.
citizens can sought
All
information.
right, no need to record. We'll see next day.
That's I'm not objective, my lord. I'm
Uh,
objecting that this
That's why,
petition
in
is
spite of whatever it may be, I've asked him to get instructions.
See, that may sort that we
No, sir.
List again on so and so. 24/4.
sort that we given.
Hmm.
Item 10, order no steps.
May I please, Lordship? Lordship, steps as regards respondent number 3, Lordship. I am taking steps today, Lordship. Otherwise, Lordship, on last occasion, respondent number 2 was directed to produce records, Lordship.
Today it is possible not taking steps on the Lordship. We'll we'll produce the record on the next, it is already, we have received it from the SSL Lordship. And it is on the way, today we have received in the second of Lordship.
List on 31/3 says,
Pardon?
today is 31/3.
31.
Oh.
That is immediately after vacation. Lordship.
Lordship.
But what about the records?
Records we have received Lordship from the SSA. Now it is, we are, after 1 or 2 hours, Lordship, I'll get it Lordship. In the second of, so let it come after, we have to go through it Lordship. Let it come after vacation immediately.
There was the order dated 10/3/2026, by which the respondent number 2 was asked to produce the records of the verification process in respect of the petitioner's case. Mr. SMT Chisti, Learned Counsel, submits that he will be receiving the records within the course of the day. And therefore prays that matter be posted after the ensuing leave vacation. Next para. Office note dated 27/3/2026 also shows that the petitioner has not taken steps for service of notice upon respondent number 3. So of the learned counsel for the petitioner, Mr.
T.A. Chaudhary.
T.A. Chaudhary,
Yes,
submits that he will be taking steps
during course of the day.
during the course of the day. In view of above, lists again on so and so.
5.
Oh, fine.
4 by. All right.
Records will be produced by the learned standing counsel.
On next that Lordship, we definitely produce.
Elementary education. on the next date in terms of the order dated 10/3/2026.
Positively.
For orders, item 19.
In this matter, I was directed to obtain some instruction whether the benefits has been given or not. Consequential, he has been reinstated already, Lordship. That's it. Today I have been, I have received one instruction that proceed that some time may be required. Lordship, to provide the status.
Here in this case, my lord, the two part of the judgment, my lord. One part is for reinstatement and the next part is for financial benefits, my lord, consequential financial benefit. That benefit has not been given. Petitioner was reinstated already.
Consequential relief.
Yes,
Because that part, I have been instructed to obtain some time, Lordship, so that the status report can be filed. Today morning only I have received this.
Where was the order dated 12/3/2026, by which it was recorded that one part of the two direction of this court has been complied with, and that the consequential relief after reinstatement of the petitioner is yet to be complied with. Stop. Therefore, the matter was directed to be posted today. Stop today, Mr. A.R. Tahibildar, learned counsel appearing for the respondent, submits that he has been asked to obtain, he has been asked to seek for 2 weeks' time. So as to enable the Directorate of Higher Education to place the status of the case before the court. Considering the same, matter stands adjourned for 2 weeks. List again on so and so.
Made by the
29/4, why? You said 2 weeks,
Yes, yes.
more than 2 weeks.
much obliged, yes, ma'am.
Item 20.
Lordship, may I kindly peruse the last order.
Speaking order.
Last order.
Speaking order was supposed to be produced. Where is it?
Some time, my lord.
Some time.
Fine.
How much time?
2 weeks now.
On 6/3/2026, Mr. P.K. Bora, learned counsel appearing for the Elementary Education Department, was asked to produce the speaking order. But today he submits that he is yet to receive the same and prays for 2 weeks' time. Praise aloud. List again on so and so.
Obliged.
21.
Thank you, Lordship. As per office date dated 26/3/2026, till date no ID card nor answer notice has returned. Back to the respondent number 1.
How many respondents are there?
So 4.
Hmm?
4 respondents.
4 respondents. So regarding 2, 3, and 4, they are represented.
Rakhi sir.
Suranjana Senapati, Rakhi Sahu, Devojit Gogoi.
Devojit Gogoi, he is no longer a DI of Tiptagore at right now, Lordship. He has been transferred to Hemaji. Anyway, I can contact him, Lordships. As far as that DO is concerned, I have to take one. And one Pitam Seke হয়েছে নিতে হবে।
Naran,
Please fill it.
Naranpur.
Service.
April also.
Check this out.
One is not served. Pritam Saike.
Yeah, Pitam Seke has retired long back. They have included the new secretary. Now
Who-
they have taken steps, Lothin.
Who is that?
And Narayanpur. Pitam Seke retired long back, Lothin.
But have you filed the cost title, amended cost title?
Amended cost title file থেকে লইব। You have to find an amended cost title. Narayanpur আনি পেলাই।
By which order was it amended?
কইলে না। You have to find the content petition. The amendment কৰিব লাগিব, cost title. Only then I could reflect কৰিব, not Pitam Seke reflect কৰি আছে তোমাৰ।
Oh, it's here.
And for 2, 3, 4, I am appearing lawsuit.
Hmm.
Yes, I am
It's
appearing.
here. Narayan Kaur is there.
Yes.
Then Suranjana Sirapati, Rakesh Sahu, and Devojit Gogoi.
Only-
All of them.
To be appeared lawsuits, I will inform lawsuits,
Hmm.
but other I have appeared.
You're appealing for the others
Yes,
also.
yes.
What is the instruction otherwise?
Well, we need some time lawsuit because I don't have that specific instruction regarding this case. Regarding response number 1 lawsuit, I'll take instruction lawsuit. Let it come immediately after vacation.
All right, please write. Office note dated 26/3/2026 indicates that neither ID card nor unserved notice has come back from respondent number 1. So at this stage, Mr. SMT Chisti Learned Counsel, who represents respondent numbers 2, 3, and 4, submits that he will inform the respondent number 1 about the pendency of this contempt petition and praise that the matter be listed after the ensuing bifurcation. So that he can get back to the court with the status of the case. Considering the submission,
Secretary.
list again also and so.
Apply it.
22.
May I pray after some time, my lord?
Huh?
After some time, my lord.
Sometime. What is this matter? This was listed for orders.
Those orders. The I pending.
IA is for?
It's a very small, very small issue. And can be disposed of within no time. Now nothing is left in this matter.
It always starts like that, very small issue, then the
Yes.
councils end up arguing the whole day.
After some time, my lord.
Huh? What is this IA for?
I is not to take any coercive action against us, my lord.
Lordship, we are not taking any course of action.
My lord, been taking up for some time. The IA that we have filed. What had happened, my lord? A sexual harassment case I had filed a sexual harassment case. At that time, what had happened, I had been posted by this honorable court. I was posted in the Department of Emergency.
You are the victim of sexual harassment.
I'm the victim, my lord.
Okay.
And thereafter, they completed the disciplinary proceedings against the accused and they found that he's not guilty.
Okay.
And that was the disciplinary proceeding on the face of it was done in a sabotage manner. Thereafter, they terminated my service. And thereafter, my lord was gracious enough to protect me, and I've been protected by my lord's order. And thereafter, what they have done now to suffer more injuries, they have again posted me before the same person, under whom the person against whom I have filed a complaint.
Okay.
Whereas for the POSH Act, for the time, if it's because I have a chance of appealing against the authority and my appeal is pending, they could not have shifted me there. That is why the IA is for. And their IA is for stay vacating. So what
What are you otherwise?
I am a doctor in pediatrics, my lord.
Working in
Working in AIMS Gauhati, my lord.
AIMS Gauhati.
Yes, my lord.
Pediatric doctor.
Yes, my lord.
And the complaint was against?
This complaint was against the HOD of the Department of Pediatrics.
I see. So
And my lord,
by this IA, you want some protection,
yes, my lord.
not to be posted there.
They're not to be posted. They're posted back to the department where I was
working. That was accidental and emergency.
But medical line, they have a kind of speciality in
Yes, my lord.
every field.
Yes, my lord.
If you're a pediatric doctor, you'll have to be there.
No, my lord, when the urgency, even in accidental emergency, the first, when there is anything with the emergency, with the child also happened, they come to the emergency wing only. And from there, the Department of Pediatrics, they have to take it away. They are
Okay.
not, they are medicinal doctor. They are not surgical doctor, my lord. It is Department of Pediatrics and Medicine, not pediatric surgeon they are. So I am a pediatrics and a medicine where my service can also was being utilized in the Department of Emergency also.
Emergency, anybody can be there.
Yes, somewhere. So
Surgery and whatnot.
so it will not anyway affect if I'm posted there, or it will not be affected into public interest. So, my lord, what I'm just
So when did you file your IA? Is there a response to that?
Neonatal now.
no, I don't have a specialized.
Neonatal, which is connected with pediatrics.
I don't have a I don't have a specialization in neonatology. How can they post me in neonatal?
Lordship, it's one of the branches of.
No, my lord, may I just submit here? The learned respondents have confused the fact that AIMS in their website have different department for neonatologists and for pediatrics. And after you do your MD in pediatrics, DM is the post of neonatologist. I don't have the requisite qualification to be a neonatologist, and you're posting me there. Tomorrow, if something happened to a neonatal, you will curve my finger, you'll curve my neck, and you'll say that because of you, this has happened. That is one of my ground that I have stayed.
Okay, anyway, you filed this application for that.
Lordship.
No.
I want of yours.
No, just a minute. You have filed this IA for
Yes, my lord.
seeking for
my
change of posting.
to place me in the Department of Accident Emergency where I was working
Okay.
before this order was there.
Okay, then you have filed a response to this IA.
Lordship, we are fine. Department should ask.
No, that will consider.
Lordship, secondly, here is economical with the truth in there. This repetition which is.
Mr. Counsel.
It has already been disposed of.
Which writ petition?
The one which they are referring to.
The one which I already submitted that. The one, Lordship, I was given a protection.
That has already been disposed of, your lordship. 5090.
This is IA in a disposed case.
No, my lord.
Sir, lordship.
The writ petition number 2316 relating to the sexual harassment which is mentioning has been disposed of at the admission stage itself.
Okay.
I have a copy.
Then what is this writ petition now?
No, my lord.
now-
Again, they are submitting the facts as per their own math. Please, let me submit here. What, my lord, they have done is this.
See,
My lord, they are trying to
This
comfort the facts.
petition Is against her, the
See,
termination order.
if we switch off the live streaming, will it make a difference? Let us not put up a show here.
My lord, what?
Because this code is one code where you have to argue in a
Yes, my lord.
in a sober manner.
Yes, Lord.
Everybody gets his turn. Because with great patience, I'm hearing.
Yes, I understand, my lord. I please, my lord, but they are just
And-
jumping.
and-
They're jumping out here, my lord, because
And at the beginning, you said that let it be passed over sometime. We'll be
Yes.
passing now. I just wanted to know what the matter was.
Yes,
And you started arguing.
my lord, just a
This is
simple.
that case. This is this
The
case.
history of the fact is that there was a writ petition which I've already said, my lord, was filed before this honorable court, where I has stated that the Department of AIMS has not taken a proper action
All
against
right.
my complaint.
All right. Let us stop here for now.
Yes, ma'am.
Who will be arguing the matter?
My lord, Mr. Kane Chaudhary, my lord,
Okay.
senior
So,
advocate.
all
He's
right.
there on legs on court number 1, my lord.
Let him come. We'll pass it over sometime.
Lordship, small request.
Yes.
Come all the way from Delhi representing the Ministry of Health.
Okay.
I have got a flight in the evening. If it can be taken, it's my humble request before lunch. If it can be taken, I will be really grateful.
There's enough, still some time. You make an endeavor.
He's in court number 1, he'll be just coming, my lord.
Make an endeavor to come
Hello.
back before 1.
My lord.
Time being.
23, 24 and 25.
Yes.
Wait, please, your lordship. Lordship, senior is on legs. The matter may be taken after some time.
Who is on legs?
My senior, P. Kumar.
P. Kumar. V. Kumar. Okay. What is this IA?
Lordship, this is filed by Union of India.
For?
Lordship order, we are asking for 6 months extension of time for compliance of lordship order
That much only.
only.
So what is that? 6676 IA?
Because three petitions are taken up together by a common order, so I have to file three separate IS, but same order, Lordship will find and pays.
All the three IS you are seeking for
Yes,
3 months' time.
Yes, 6 months time.
6 months' time
6 months
for compliance.
for compliance.
You have objection to that?
I have no instruction regarding
Okay, let your senior come then.
Lordship.
Time being.
27.
Not in item 26, there's an office note, my lord.
Yes, what is that?
Office note says that we had taken steps, but the order was that steps has to be taken to respondent 8. There is no respondent 8, but instead it should be respondent 7.
So a fresh order is required.
Fresh order means as regards there is no respondent 8, so we may be this notice may go to respondent 7. There's no respondent 8. There's still only there is respondent still number 7.
Correct. That's why another order is required
Yes, ma'am.
for modification of that order.
Yes, ma'am. And the other respondents, they have to file their affidavit.
Peruse the order dated 9/3/2026 as well as the office note dated 27/3/2026. Stop. It appears that inadvertently, instead of directing steps to be taken for service of notice upon respondent number 7, comma, respondent number 8 has been reflected to be served notice. So it is seen that there is no respondent number 8 in the writ petition. And accordingly, there is no dispute to the fact that steps have to be taken for service of notice upon respondent number 7. How much time? Steps.
Steps, my lord, within 3 days, ma'am.
Okay.
We have already taken steps upon respondent 7. Office note shows that, ma'am. That we have taken steps, but since it was inadvertently shown, office note shows, my lord, that we have taken steps on 7.
Accordingly, let notice be served on the respondent number 7 by speed post. Since the petitioner has already taken steps, office to do the needful.
Yes, madam.
I pay for the office of the accountant general respondent number 5. Extra copies have not been served.
I'll verify. I think I have taken steps, but if not, I will serve him copy.
Extra copies be furnished by the petitioner to the learned counsel declaring for the
Copy.
remaining respondents within 2 days. Mr. B. Chaudhary appears for AG Assam.
B. Sharma.
B. Sharma. B. Sharma appears for AG Assam. S. Bhuya for 1, 2, and 4. R.K. Talukdar for 5.
Item 27 for number 6,
A. Barua for respondent number 6.
Interim may be extended in item 26, my lord. 27 interim is been extended, but 26 interim has to be extended.
Interim in which case?
The item 26, my lord.
Are you sure?
Yes, madam. 27 interim is there. 26 interim has to be extended.
Interim order passed earlier in WPC number 1318 of 2026. To continue till the next date of listing. Yes. List again after 4 weeks.
Permission item, what is?
Well, as per the last order, that is on 3/5. The respondent number 4 has to file the affidavit, and moreover, my lord, the respondent number 1, 2, and 3 also not file their affidavit, my lord.
My lord, affidavit is ready, my lord. I have communicated to the present incumbent, but he did not came to sign the affidavit.
Which respondent?
Respondent number 4, my lord. Earlier, respondent, my lord, retired from his service.
Earlier
Now-
incumbent is retired, so new incumbent has
New
joined.
incumbent is come by, but he's not cooperate with us. For them to cooperate.
What is your case?
Already informed, my lord. I have already informed the present incumbent.
Affidavit is ready.
Affidavit is also ready, ma'am.
Why is not cooperating?
I don't know.
Then you tell him, I'll not appear for you. You go yourself and appear before the court. We'll call him otherwise.
This is the only way I'm.
Why is not cooperating? Any specific reason?
No, man.
What is your case otherwise?
My lord, this is relating to, my lord, the reduction of the salary.
Hmm.
The petitioner was earlier, my lord, the enhance her great pay and salary today, my lord, from the month of July 2017,
Hmm.
to the tune of, my lord, 41,000. And after drawing this salary, suddenly, my lord, from June 2018, that salary has been reduced by reducing the great payment. So without any reason, without any, my lord, cause, without showing any reason, my lord. So I have filed representation after one another, but no response has been received. So that,
Kim.
my lord, I have filed.
AC? Very warm. So what is to be done today?
But the respondent number, my lord, 3 also, my lord, is a necessary party and he has to file the affidavit. Inspector has not filed affidavit. 1, 2, and 3. At least, my lord, 3 has to respond.
Yes.
Mr. P. Mahanta, please write, appears for the petitioner. While Mr. For one, two. Secretary, Education, Secondary,
I am a representative secondary.
Mr. P.P. Datta, Learned Standing Council, Secondary Education Department. Appears for respondent numbers 1,
1, 2, and 3.
2, and 3. And Mr. K. Kolita, Learned Council appears for respondent number 4. 5? Anyone? Notice is served? 5?
I also am.
Huh?
I also I. Because alia color number 4 and 5 I have filed.
Okay, right, Mr. So 4 and 5, huh? The Learned Council for respondent number 4 and 5 submits that affidavit of respondent number 4 is ready. But the respondent number 4 is not cooperating in the matter. Counsel for the petition also submits that affidavit in opposition of respondent numbers 1, 2, and 3 would be necessary. In view of above, further 3 weeks' time is granted to all the respondents for filing the counter affidavit. List again on Swenson. 6-5.
Must apply.
I think that
It pleases your lordship.
Hmm.
My lord, as per your lordship last order, my lord, the pleadings are complete in this matter. But the issue is in a very narrow campus, my lord.
Yes, what is it?
My lord, These petitioners, my lord, they are the stenographers grade 3 under the SCRT department, my lord. This SCRT department comes under the education department. Now, my lord, initially when we were appointed, your lordship sees from page 30 to 91, these are all my appointment orders and my joining letters. These are all regular appointments, my lord. They were all given the grade pay as well as the scale which was prevalent at their time of their appointment.
Stenographer, grade 3.
Grade 3.
Date of appointment is
Because my lord, since petitioners are different, there are a number of petitioners.
between which period,
Between-
broadly?
From the period, my lord, 1999 till latest is at page 86,
That is?
2023.
Hmm.
My lord, I have prepared one table.
The issues regarding grade pay.
Yes. The issue is regarding the grade pay. What has happened, my lord?
Yes, you want to say something?
So perhaps a date may be fixed on the second week of May, Lordship.
You are appearing for which party?
For Finance Department and SCERD.
Why?
Lordship is on legs in court 1. A date may be fixed for hearing, Lordship.
Mr. Counsel.
My lord, finance will be required because ultimately in the affidavit of the finance, they have said that I am entitled for 8,700. The only issue is that they have not done the review of the cadres.
All right.
Because
So
the cadres which are there,
let us have a date then.
my lord. But my lord, second week of May, my lord, it will be difficult, my lord, because these petitioners, they have been suffering from 2024. Even though there is an interim order operating, but my lord, the next pay commission is about to commence. So if this issue persists, then it will affect their next pay commission. My lord.
Yes, can we have a date sometime? First week?
Can it be on the first week of May then?
That's what we're saying.
Fine.
Mr.
Came on.
It is submitted at the bar that the pleadings are complete and the matter can be taken up for admission hearing. Stop. However, it is submitted on behalf of Mr. P. Naik that he is engaged in a different court and therefore some accommodation being made. Considering the same and as agreed to by the parties, let the matter be listed on 7/5.
Can it be on 5th, my lord? 5th of May. It's a Tuesday.
7/5, my lord.
Let it be, my lord, 7th.
7 is okay.
My lord, can only be a direction be given that endeavor may be made to dispose of the writ petition on the next day.
And David is always there,
But my lord, if there is
irrespective
a
of observation or not.
lordship's observation, then it will be helpful. my lord.
Okay, on which date an endeavor shall be made to dispose of the case finally?
I'm deeply aware.
That's
30.
Lordship, in this case, Lordship, that we have sent the affidavit in opposition for vetting, Lordship. There was some confusion, and today we have corrected and sent it for vetting again today. So let the matter be fixed for verification, and then it will be filed.
Yes,
Lordship, the affidavit.
All right.
is sent.
Mr. P.P. Datta, Learned Standing Counsel, Secondary Education Department submits that some rectification was required in the affidavit in opposition and which he has done. He submits that since the same has been sent for vetting by the department, he prays for some time to file the counter affidavit in view of above. And that's paid for list again on search. 12/5.
15.
Yes,
My lord, regarding non-payment of medical reimbursement, my lord.
okay.
My lord,
What is the stage now? You have filed a response?
no, my lord, despite my lord taking time on several occasions, my lord, no affidavit doesn't file, my lord.
Which is department? Elementary?
My lord, yes, my lord.
How much is the amount?
My lord, the amount is, my lord, I have mentioned at paragraph 7, my lord,
2 lakhs.
2,10,000
Uh,
669, my lord.
But are you entitled to reimbursement?
My lord, as per my lord, notification, my lord, I am entitled, my lord.
When did you submit your bill?
My lord, I have submitted, my lord, actually, my lord, what happened, my lord, in terms of notification, my lord, I have to submit online application, my lord, but which I could not done, my lord. Thereafter, my lord, as per advice of Promotional 5 and 6, I have submitted offline application, my lord.
When?
That is, my lord, at page 14, my lord.
When is that?
Sorry, my lord, that is 18th April 2024.
Yes, where is your affidavit, Ms. Lukan?
Well, in this case, we have not received any instructions, so sometime.
My lord, may I pray for disposal of the, my lord, the direction maybe should, my lord, to dispose of my representation. My lord.
Yes, ma'am.
Where is your
My lord,
representation?
my representation is at page 42, my lord,
Yes, ma'am.
and except 14.
The problem is, have they received it?
My lord, there is no receipt number, my lord. Actually, what happened, my lord, we submitted the application, but my lord, they did not, my lord, issued any receipt number. My lord. That is
This is
the,
the problem. If they have received with
My
seal,
lord,
signature,
then,
receipt
my lord,
number, then would have considered.
Then, my lord, we will be directed to submit, my lord, a fresh representation along with read petition, my lord.
No, it's better to get instruction. What do you say?
Kindly matter will fix after vacation in the meantime.
No, fix after vacation or next year something. I'm asking you, what is to be done? Somebody has,
They can file a new representation, ma'am.
Yes, along with, my lord,
Along with
my lord,
this
this
petition.
appeal, read petition, my lord.
okay, please
With
write.
the
Hard,
time,
Mr.
my lord.
Hard, Mr.
A. Hussain, my lord.
A. Hussain, learned counsel for the petitioner, and Miss N. Fukan, learned standing counsel, elementary education department. Stop. Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Stop. By filing this writ petition, the petitioner has sought for a direction to the respondent authorities concerned to petitioner is a he or she.
My lord,
He, my lord.
he,
He. Seeking a direction to the, what did I say? To grant him medical reimbursement amounting to rupees 210,669 in terms of notification dated 19/12/2023, which he has incurred. For what have you incurred?
my lord.
What is your ailment?
My lord, my ailment, my lord, my wife was, my lord, met with an accident, my lord. That is, I have stated, my lord.
For which he has incurred due to the accident met by his wife.
Yes.
Where is the notification?
Notification
22.
that, my lord,
22.
page 22, yes.
Where is the relevant one? Relevant portion.
Relevant person, my lord, my lord,
You're not sure about anything, but and you want the disposal yet.
my lord, clause 7, my lord. Page 26.
Clause 7.
Yes, ma'am.
Read, what does it say?
My lord, the submission of medical reimbursement claim and process of adjudication, my lord. An employee pensioner will have to give intimation to Atal Amrit Provision Society through MMC, MMLSAY, a dedicated toll-free phone number within 24 hours of hospitalization regarding treatment in the concerned hospital by giving details of the patient, treatment and treating hospital.
Okay, right, this the referring to the notification dated
19/12/2023.
where's the date?
My lord, page 28, my lord. 19/12/2023.
Notification dated 19/12/2023, bracket annexure 5, More particularly, clause 7. The learned counsel submits that the petitioner has
I have also explained, my lord, that paragraph 8, my lord.
complied with all the requisites mentioned therein. But despite the same, the medical expenditure incurred by him for treating his wife has not been reimbursed. The petitioner then approached the commissioner and secretary to the government of Assam, Medical Education and Research Department,
And also, my lord, director of elementary education, Assam Kahilipara.
secretary to the government of Assam, Department of School Education, and also the director of elementary education, by submitting a representation on 18/4/2024. But since the same has not been considered and disposed of, the petition is before this court. Next para, although notice of motion was issued on 9/5/2025, the respondents have not filed their counter affidavit till date. Stop. Having regard to the fact that the representation of the petitioner has not been considered till date, this court deems it fit to dispose of the writ petition by directing the petitioner to file a fresh representation before the which respondent?
My lord,
Ms. Fukan, you don't have the file. You should assist the court. Before whom?
For the Director of Elementary Education, respondent 3, ma'am.
Before the Director of Elementary Education, Government of Assam, within bracket, respond number 3. Along with all supporting documents within a period of
my lord,
10 days from today.
my lord.
So upon filing of the said representation, the respondent number 3 shall consider the same and dispose of the representation by way of a reasoned and speaking order within a period of 1 month of receipt of the same. We receipt dispose of. With the above observation and direction, the petition is acceptable. Before that, you write a copy of the order to be passed by the director shall be given to the petitioner.
Oh, bless me.
This is item number 15, is it? Just come back in short while.
So this is second round of litigation. In the earlier round of litigation, this honorable court directed the district scrutiny committee to take a decision. So ultimately, the district scrutiny committee has taken decision that you will find at page number 37, annexure 13. This was done on 20, yes,
Last
29/1/2025.
Lordship has directed us to bring the status of the SC.
So now
SLSC matter.
small issue is there, let's say
I need some time on 26/6, 2025, kindly see the order dated 26/6.
Otherwise, also the matter is, let's say, as per the act, lordship, after recommendation made by the district scrutiny committee, it should be placed before this state level scrutiny committee. Now, matter is now pending before this state level scrutiny.
Okay, just a minute. Let me read the order. So court wanted to know whether it has been placed or not.
Yes, so.
What is your instruction?
I need some time. I have not, I have communicated to the authority.
Sometime means this was order dated 26/6/25
True, I have gone through.
last year.
Can be immediately after vacation now.
So as per the provisions of the Act, Lordship, it is their duty to take a final call. That decision is not taken, so yet to be taken.
One last.
So matter may be disposed of.
Lots may dispose of them.
So we dispose of with the direction to the state level scrutiny committee to take a final call on the recommendation made by the district scrutiny committee.
If not already taken, can we dispose it of that way?
My lord.
I heard Mr. A. Deka, learned counsel for the petitioner, and also Mr. P.K. Bora, learned standing counsel, Elementary Education Department. Of this court on 26/6/2025, pass the following order. Please abstract the entire thing. Next para, as may be noted from the above abstract, comma, this is the second time the petition is before this court. And that a recommendation has been made in his favor by the District Scrutiny Committee, which held its meeting on 19/1/2024. Stop. However, it is the case of the petitioner that, despite the same, the matter has not been placed before the state level scrutiny committee for further necessary action. Stop. This court, therefore, on 26/6/2025, required the learned standing counsel to obtain instructions as to whether the case of the petitioner has been placed before the state level scrutiny committee or not. So today, Mr. P.K. Bora, learned standing counsel, submits that he has not received instructions yet and submits that he may be given some more time. Stop. However, considering the issue, this court is inclined to dispose of this writ petition by directing the respondent authorities concerned to place the case of the petitioner before the state level scrutiny committee in view of the recommendation made by the District Scrutiny Committee, Borpeta, on 19/1/2024, if the same has not already been placed in the meantime. Depending on the decision arrived at by the state level scrutiny committee, necessary follow-up steps be taken without delay. With an intimation to the petitioner. With the above observation, direction, petition stands disposed of.
The time frame may be given, otherwise it will be again pending.
If not already done, I said, na? To consider and place before the state level scrutiny committee. What is the line? Mr. P.K. Bora, place for some more time, I said, no? However, instead of okay. In view of that, then. So before that, already, before in view, you write this. Within a period of
2 months.
scrutiny committee, they'll place
1 month.
within a period of 4 weeks. From today. In view of the so and so, no? Then just continue reading.
By the state
All right.
Level scrutiny committee shall pass a revision order within a period of 4 weeks, Lordship, regarding the entitlement of petitioner based on the recommendation made by the district scrutiny committee. After receipt of the order of this honorable. Yes, yes. But they have to pass a revision order, Lordship, on the recommendation of the district scrutiny committee. That
All
will
right,
be
I'll take care of that as advanced.
17.
17 here, Lordship. Supposed to get instruction, Lordship.
May I please your object?
Yes.
Lordship, I am seeking a short accommodation, Lordship. Instruction is awaited.
How much time?
3 weeks time, Lordship. Just some verification is going on, Lordship.
Miss S. Kaur Lanet, Standing Council, Limited Education. Prays for further 3 weeks' time to obtain instructions in the matter. On the ground that some verification is under process. And therefore, she needs to get the updates. Stop. Praise allowed. List again. 265. Mm. The primary matters. Which was that primary matter? Oh. 22-4. We call this 23-24 to 5. First. Require is not there. No problem. Yes, this item number 21 and 22. No, 22. Parties are ready.
We are ready.
Mr. Ken Chaudhary is not here.
Okay.
Huh? Yeah, please do that. Now, if we start the hearing matter, then this will not come up.
Team 28-29 is there. It's a short matter 2013.
Everyone's saying short matter. I don't know whether it's short matter or not.
It's a short matter. Except, it's a matter regarding promotional. Proposal was sent, it has not been finalized. Then ultimately, the petition was dismissed on the ground that government school cannot be promotional.
Minor.
It was filed. She is the petitioner. I am respondent number 8, 9, 10.
Oh, you're for respondent.
Yes.
8, 9, 10. Who's that?
Petitioner in item number 28, Your Lordship.
Which respondent is that? 8, 9, 10?
In this case, I am respondent number 8, 9, 10.
Who are they? Private respondents.
Private.
29. 29.
29.
In 29, Your Lordship, they are the respondent, Your Lordship. 28, I am the petitioner, Your Lordship. 28, Your Lordship.
I am respondent by 18, 19.
Parties are there. Parties are all.
Yes.
All are there.
Ultimately, my lord, your lordship has to, I think, according to me, my lord, subject to what he said. The matter has to be decided by the director. Because provincial proposal was there, it has not been acted finally.
Acted finally because, Your Lordship, in the meantime, Your Lordship, the process has started, Your Lordship, because of the filing of the next item 29, 390, 13, Your Lordship. Because of that, Your Lordship, the process got stuck, Your Lordship. Otherwise, in my case, Your Lordship, there are two petitioners, Your Lordship. Against me, there is no claim of seniority, no other claim, Your Lordship.
What is this IA for? IA?
Lordship.
IA 105?
Your Lordship, that is a simple thing, Your Lordship. I have been barred from attending in online, Your Lordship, Your Lordship, giving my attendance, Your Lordship. So for that reason, I have filed this IA, Your Lordship. Online, Your Lordship, there is status, Your Lordship. Where, Your Lordship, my name was earlier there. Now that was not there, Your Lordship. Might be because of the pendency of this case, Your Lordship. Otherwise, their cases, Your Lordship, yes, Your Lordship, the respondent, Your Lordship, against this respondent, some claims are there, Your Lordship. Because what is the matter very precisely, Your Lordship? Because there is a Catholic mission ME school, comes under minority education. So earlier in the 2013, Your Lordship, one judgment has been delivered, Your Lordship, saying that the petition is not maintainable because they comes under minority education. Under Article 30 of the Constitution, Your Lordship, comes under. For that, Your Lordship, the respondent and petitioner, Your Lordship, of the 339/13 filed their review respectively, Your Lordship. That has been allowed, Your Lordship. That order is also there, Your Lordship, that has been allowed. That impune effect of minority education has gone, Your Lordship, from that time, Your Lordship. It was in that year of 2025 when that impune effect has gone, Your Lordship, of minority education. Because of that, Your Lordship, the whole process has got stuck, Your Lordship, provincialization process, Your Lordship. In my case, Your Lordship, this petitioner is out of blame, Your Lordship, because there is no seniority claim. I am within the schedule, Lordship list, Your Lordship. There is no seniority claim. Now, Lordship, Director of Education, Elementary Education filed their affidavit claiming that, Your Lordship, because my prayer is to provincialize my petitioner, Your Lordship, under 2011 Act, Your Lordship. Now, Elementary of Education Department says, Your Lordship, that the school comes under minority education and 2011 Act has struck down, Your Lordship. Their main allegation is true, Your Lordship. So I'm ready on that ground, Your Lordship.
Mr. P.K. Bora,
My lord.
are you ready with this matter?
Yes, well, what's it, may I take immediately after vacation?
Your Lordship, because all the petitioners, Your Lordship, now
Why, you're not ready?
We have filed our affidavit.
You're not answering also. You are just going repeating around the bush.
My lord, no issue, my lord. I can argue to my.
If you say no, I will not start. If you say yes, we can start. That is the only thing. You have filed affidavit and all that. That's not
is
the.
under also, Your Lordship.
That is why it's listed for hearing.
Lordship.
Is that a short matter?
Here, my lord, issue
so long, Your
that my lord, she is claiming under old Act, which is not in Act right now.
So is it a short matter or a lengthy matter?
Not so bad.
Take it up, short matter.
Short matter.
The only thing is this, whether she is entitled under the old Act or not. She is not entitled, my lord. This cannot be, because old Act is already stuck down. Anything has to do in the new Act.
I am relying for that, Your Lordship, delete this case, Your Lordship.
All right. Call. They're here. Okay, let us have this orders matter first.
Lordship, Lordship.
We might have some time in the afternoon also, Mr. Das. Court is rising at 3:15. So 2 to 3:15, we still have some time because there are no other matters as such. There's one matter in which some IA is there and some senior counsel. We'll see. We'll see. Yes. What is this IA? At 2. It's better at 2.
Lordship, this is by Union of India for praying for extension of 6 months' time for compliance of Lordship order. Because this direction is that cadre review of the petitioners.
Okay, show me the direction.
Lordship,
On last date.
Madam, what do you want to say? You want to seek adjournment? Then don't interrupt.
My senior asked, they can't have 6 more months.
Oh, let us submit first. Oh, you want to start submission first? It's our IA. Whether to grant or not, that we'll see.
page 33 is for the portion of Lordship order.
Group C, isn't it? From the Assam Rifles. Barber, Safai, EVR, Carpenter. Cadre review.
Lordship.
So that cadre review, you want some more time?
Lordship, I have stated that there are a large number of petitioners, so we have to verify all of their credentials, etc. And that is the, and then we have to send it for ministry for approval. Therefore, it takes some more time.
Okay, but time was granted to you since when?
It's an order of 1/4/2025.
Correct.
6 months time.
6 months time.
Lordship.
You want 6 months times additionally.
Yes.
6 months from today,
Today or date of filing, whatever, Lordship.
date of filing. You're proceeding like an MSCT case over date of filing and all that.
Because they are objecting that we are taking more time. That's why I'm saying Lordship.
Date of filing is February.
Yes, 20.
Today is we in March, just
Yes.
a matter of 1 month.
Lordship.
What is the justification?
Paragraph 4, Lordship. Paragraph 4 and 5.
Current proposal is in the final stage, pending before the Ministry of Finance.
No, that is the order. That is the order. Paragraph 5 is our ground that. That is.
Paragraph 5 is the reasoning given by you.
Yes, Lordship.
Please read it.
Page 13.
Please read it.
That the applicant state that the authorities are doing their best to comply or implement the common order dated so and so. However, as there is a large number of petitioners, the authorities have to verify the detail of each of the petitioners. More so, prior to compliance or implementation, the approval from the ministry is also required. Process for compliance or implementation of the common order dated 1/4/25 is under process. However, the authorities requires further 6 months time to complete the process. As such, we are praying for extension of 6 months time to comply or implement the order.
So this is paragraph 5.
Paragraph 5. Paragraph previously, that is the order, Lordship, that I have quoted.
Yes.
My lord, the order was passed on 1st April 2025, my lord.
Correct.
And the 6 months time was granted to the department. It has been lapsed, my lord, on 1st 10/2025, my lord.
1/10/2025.
Yes, my lord. 6
Okay.
months time has been gone, my lord.
And when was the application filed?
I filed it in the month of February 26.
Why?
They are trying to come.
No.
Yes,
The trying to is a different thing, Ms. B. Sharma.
but as it was not completed.
No, see, thing is that a time frame is given to you. And it comes to your notice that we will not be able to complete within this time. Immediately before expiry of that 6 months time, you should have applied.
Got it.
That is what is done normally. But you waited for a few months thereafter,
It takes-
after 110,
yes,
after
Lord.
4 months.
They are trying, but as it was still not
After
completed.
4 months, you applied for extension
Yes, Lord. That's true.
with your expectation that court will give you another 6 months time.
Trained, Lord. That point I have told my clients also, but
No, this is not done otherwise.
that's true. But as they could not
Keep that in
complete.
mind. This is not done. Because before expiry, you should ask.
Lord.
Supposing your license, vehicle license, driving license, you have to renew it before it expires. If it expires, then what do you have to do? You have to pay cost. Are you willing to pay cost?
Lordship, I will be praying because the reason ground is that they are.
Yes, Mr. Counsel, we have to be reasonable.
My
They are on the process of complying,
my lord.
considering your case.
My
So we should give them some
My lord, I
time.
need 2 months maybe given, my lord.
2 months.
Yes, my lord, because
5 months has already been gone, my lord. After expiring of the time frame given by the honorable court, my lord.
He is right also. 6 months from 110
Lodging.
will be this month only, next month.
Yes, at least in between lodging, something. Although it's not a case to again the time lodging, but anyway lodging, because 2 months probably will be a shorter period.
All right, please write hard, Ms. B. Sharma, Lanet CGC, appearing for the applicants, who submits that the connected writ petition, that is WPC number 4423 of 2024, was disposed of by this court. Divide common order dated 1/4/2023, 25, sorry, 1/4/2025, with the direction that the respondent authorities should complete the process of gather review as expeditious as possible, and preferably within a period of 6 months from the date of receipt of a certified copy of this order. So the learned counsel, the learned CGC submits that despite the endeavor made by the respondents, applicants, to complete the process within the time frame, they are unable to do so. And it is for this reason that the instant application has been filed. So stop. In this connection, she refers to paragraph number 5. Paragraph number 5 of the application, which is reproduced here as under A to A, page 13 and 14. It's a pink flag, okay? Next para, Mr. Your good name?
V. Kumar, ma'am.
V. Kumar. Mr. V. Kumar, learned counsel for the respondents.
My lord.
How many respondents are there?
Many respond, 3 cases here.
No, we're talking about one case.
11, yeah.
11.
First one, there is 11 respondents.
Okay, appearing for the respondents, writ petitioners, submits that sufficient time has been granted to them. And in fact, the 6 months period given expired on 1st of October 2025. He therefore submits that if time is to be granted, same should be not more than 2 months. Next para, I have considered the submissions made by the learned counsels for the rival parties and also the materials available on record. Ideally, the applicants should have sought for extension of time before the expiry of the 6 months period granted to them, instead of filing the application much later thereafter. It is, however, seen that from the statements made in paragraph 5 of the application as abstracted herein above, the entire exercise requires approval of the ministry concerned, and that the same also demonstrates that the case of the petitioners for having an avenue for advancement in their career is under consideration of the applicants. Such being the position, this court is inclined to grant some more time to the applicants. Accordingly, the time for complying the common judgment and order dated 1/4/2025 stands extended for another period of 4 months from today. Stop. It is also made clear that no further extension of time will be granted. With the above observation and direction, the application stands disposed of. Similar order in the other cases, okay?
Petition number and.
Only the case numbers will differ. Huh? No, this is the same. Give me the IS. This one is item number 23, okay? Item number 24, you write WPC number 3273 of 2024. Paras are same?
Same.
Paragraph 5.
5.
And the wordings are also same?
Lordship, same.
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 Copy paste.
Because the 3 repetition I make 3.
Okay. I think it's same. So 24 is that case number I've given you, and this is 25. That one. In item 25, it's WPC number 4424. Rest I will say.
Much approved.
Deep lordship.
What is to be done? You have come all the way from Delhi.
Yes, Your Lordship.
And you have a flight to catch at what time?
At 4:35.
4:35.
Maybe 6 months ago.
One matter, Mr. B.D. Das's case is to be considered at 2 o'clock. I thought there'll be enough time to take it up now.
My lord may make an endeavor to take it at 2 if possible, my lord, because he's still on legs. Senior counsel, Mr. Kinchot, is still on legs in court.
But then what is the guarantee that at 2 he'll be available again? Yeah, anyway, we'll see. Okay. We can't talk about the future. Let us see what happens. Because today the court is rising a bit early because of the reference. That's why that difficulty is there. Okay. Grateful, Lord.
For pronouncement of judgment, item 1, WPC 341 of 2023 pertaining to Itander Ben.
Yes, thus upon an overall consideration of the matter in its entirety, this court is now inclined to interfere with the initial appointment of the private respondents and similarly with the impugned review DPC minutes, both dated 23/6/2023. Insofar as the finding and observation that the petitioner could not have been singly considered without considering the case of 20 others, SKs, who admittedly were senior to him is concerned. Further, insofar as recommendation made by the state DPC for filling up the two posts of DLR and SO, this court is of the considered view that the same will have to be reconsidered in the light of the conclusion arrived at. Accordingly, the recommendation stands interfered with. As for the petitioner, his promotion to the post of AS and SO also stands withdrawn. However, as the official respondents themselves were equally responsible for the unwarranted promotion given to the petitioner and therefore on the withdrawal of the promotion given to the petitioner to the post of AS and SO, there shall be notional fixation of his pay without resorting to recovery of excess payment of the salary already given to him. Upon the interference made by this court to the recommendation made by the DPC for filling up the two posts of DLR SO, the official respondent shall now convene a fresh DPC for filling of the said two posts by taking into account the services of the petitioners as SK in terms of his initial appointment dated so and so, along with all other candidates who are eligible to be considered for the post as on 23/6/2023, within a period of 6 weeks from the date of receipt of a certified copy of this order. Upon the recommendations being made, consequential orders be passed without further delay. The entire exercise shall be completed within a period of 3 months from the date of receipt of a certified copy of this order. With the above observation and direction, writ petition stands disposed of by leaving the parties to bear their own costs. Just check the pages, side.
Highly applies.
Finding item 22 for orders.
Yes, that's okay.
Lord, the petitioner before Lordships, she was appointed on probation by Indian Institute of Medical Sciences.
Mr. Counsel, take your seat. Be comfortable. You'll get a chance. Yes.
Indian Institute of Medical Sciences, Gauhati. My lord, what was challenged in this reputation was a notice of termination, which your lordships will get at page 134.
In the IA.
No, writ petition.
Now give me the writ.
I'll come to the IA little later.
Writ petition is regarding challenge of the termination, notice of termination.
Though it purports to be a termination simpliciter, but in effect, it is founded on some allegation. Therefore, we laid a challenge to this.
Yes, which is that page number?
Page 134. In pursuance of the terms and conditions mentioned in the appointment letter referred above, I hereby on behalf of the competent authority give notice to Nisha Doteza, presently serving on probation period, that she has been found unsuitable for confirmation while being on probation, and her services shall stand terminated with effect from 1/9/25. That is end of the notice period. It is also informed that the institute will pay 3 months of pay in lieu of the notice period, by which the notice falls short. Now, there are a lot of factual background involved in this case.
Mr. Chaudhary, one thing. The matter is listed for orders today.
Yes.
So are we hearing the matter or what is to be done?
Actually, it now matter boils down to a very small point. Therefore, it can be disposed of.
Disposed of.
Kindly give me 10-15 minutes time, I'll be able to wrap it. Because, my lord, now the issue boils down to whether the authority should accept my resignation or not. Now, while this matter was pending, my lord, I have challenged this order on several grounds. Now, if you have their own conduct, I think my task has become easier. Therefore, now I'll invite your lordship's attention to the IA. Now let us take, my lord, there is an order by which my service was terminated, saying that it is a termination simplicity. While the challenge is pending, my lord, what they have done.
What has happened to this order? Any stay order? Notice of termination?
It's continuing. Stay order is there.
Stay order is there.
Yes.
It's
There's
a-
a lot of factual background. That's why I'm telling you, lordship, my lord. Lordship need not go to all these things. I'll make it very simple. Now, please come to page 32 of the IA. IA 260 of 26.
Page 32.
Yes.
Hmm.
This was on 27/1/26.
Yes.
It is hereby informed that as per the instructions of the competent authority, Dr. Nisha Toteza, Assistant Professor in Pediatrics, is hereby posted in Department of Neonatology under Dr. Saraswati Tripathi, Professor, Head of the Department, etc., etc. Below, this is not qualified by any words that this will be subject to outcome of the repetition, that is and that, my lord. Now, the fact that I have been again appointed despite the termination order, then, my lord, the things have become very clear now. That means that earlier order stands superseded unless they clarify otherwise. My lord, there was a stay order. What is the effect of a stay order? That stay order would not open, that order would not operate because of the stay order. But it does not wipe out, enabling the authority to pass a face order.
Hmm.
That means I continue to be under provision. Now, my lord, I want to resign. Whether authority can withhold my prayer, that's the only point. If this order would not have been passed, then I would have to, place the other points in the repetition also. Now it so happened, my lord, I submitted a resignation letter. Because as per the appointment order, I am also competent to, my lord, submit my resignation. Therefore, lordship will kindly permit me to place my appointment order at page number 80.
In the IA,
No, my lord, in the written.
or in the writ petition.
This was on 10th of June 22.
Page number 80.
80, my lord.
There is an offer of appointment.
Yes.
Hmm.
Kindly see the conditions number 1, 2, and 3, my lord.
Hmm.
You will be on probation for a period of 2 years from the date of appointment. The period may be extended or curtailed at the discretion of the competent authority. During the period of probation, you will be temporarily employed and will be governed by applicable service rule. During the period of probation, you will be liable to be discharged from service at any time without any notice. If on the basis of your performance or conduct, you are found unsuitable for retention in service, or if you are otherwise found ineligible or unsuitable for being retained in service. Now, 3 is important for the prayer which I will be pressing into service. Your appointment may be terminated at any time with a 3 months notice by either side. That is, appointing authority without assigning any reason whatsoever it will be open to the institute to pay in lieu of the notice period by which the notice falls short. So, my lord, the impugn order at page 134, which has been assailed in the writ petition, is in pursuance of this clause 3 part, first part. Now, the other part. Similarly, if you wish to resign your post, you may do so by depositing with the institute, pay an allowance in lieu of the notice period, subject to approval of the competent authority. As your lordship got it, my lord.
Yes.
And the last two sentences, I'm reading it again, because I'll be resting my case on this particular clause. Similarly, if you wish to resign your post, you may do so by depositing with the institute, pay and allowances in lieu of the notice period, subject to approval of the competent authority. Now, regarding this approval of the competent authority aspect, my lord, there is a Government of India OF which I will be placing. Now, my lord, will kindly come to the IA again, my lord.
Now, what is this notice period? How many was the duration? 3 months.
3 months, 1 month. No, whatever, let us be 3 months or 1 million. Either I return my pay or I give a 3 months notice. Similarly, an employer also can give me a 3 months notice. For example, they have given me 1 month notice, in lieu they have paid something. When they did it.
1 month.
Yes.
But this condition says 3 months.
1 month or 3 months. It is on regard to principal. Now, the Lord will kindly come to page number 31 of the IA.
Yes.
Please come to page 31 of the IA, Miller.
Yes.
This was submitted by the petitioner on 21/1/26. I am writing to formally give notice of my intention to resign from my service as Assistant Professor Pediatrics at AIIMS Gauhati. In pursuance of Sub-Rule 1 of Rule 5 of the Central Civil Services Temporary Service Rule 65, and in pursuance of my submission and the direction of the Honorable High Court dated 21/26, I hereby serve 1 month's notice for my resignation. This notice shall take effect from 21/1/26, and my last working day will be 20/2/26 upon expiry of 1 month notice period. I deem it necessary to place on record that this decision has been compelled due to continued and unwarranted harassment faced by me in relation to availing the processing of my lawful leave entitlements during pendency of legal proceedings, that is so and so. Despite the administration being fully aware of my separation for my minor children and my medical and health related grounds, and notwithstanding my repeated submission and strict compliance with the applicable rules and procedure, the persistent nature of the circumstances has rendered it untenable for me to continue in service. Now, my lord, I'll give a little background, my lord. Now, the petitioner, my lord, she was subject to sexual harassment by, my lord, the respondent number. Respondent number 6. He is the head of the department, my lord. Now, my lord, the internal complaint committee constituted by AIIMS Gauhati conducted an inquiry and submitted a report upholding the, my lord, the claim of the petitioner. Now, respondent number 5, my lord, I do not know where from he has got that authority. He, my lord, did not accept the report and gave a clean sheet to respondent number 6 and harassing the petitioner right and left. Her husband's services has been terminated Now, my lord, one of the member of that ICC, who is a lady doctor, my lord, she is also facing some problem, and thereafter me. Now, for example, I'll place one order to show, my lord, how I have been treated and how judicial notice has been taken by these honorable courts. If your lordship should kindly come to page number 107 of the writ petition, my lord. I'm sorry, my lord. I'll have your lordship's kind attention to page 97. There were interim orders operating despite that. They were issuing, my lord, warnings to me. Therefore, apprehending that they might take plea of this and relieve me, therefore I approached this honorable court by filing this IA. Please come to para 7. The records reveal that main writ petition is fixed on 25 to 25. The court in IA had already directed the executive director not to take any coercive action against the petitioner, and now the order dated 3 to 25 has been passed, which is termed as a warning letter. It is also concluded in the impugn letter that conduct of the petitioner is unbecoming of a government servant and same is a violation of rule so and so, and such decision is relatable to alleged malicious intention of the petitioner to malign the image of the respondent number 6 in as much as he has filed complaint before PMO of the Health Ministry of Health, etc. Such action and conduct on the part of the executive director, All India Institute of Medical Science, in the backdrop of the litigation and order passed by this court, is in the considered opinion of the court, is suggestive of malicious action. It is none other than, my lord, this honorable court. Therefore, subject to further deliberation and the response that may be made by the respondents in the IA as an interim measure, it is provided that the warning letter shall remain suspended till the next date of hearing. This is one order. Then, my lord, will kindly come to page number 107. In the earlier round of litigation, this is the order which was passed. Page 107, please come to para 20, 21, and 22. Be that as it may, this court is of the opinion that while the impugned communication is held to be unsustainable in the eyes of law, as the same was issued by an authority without jurisdiction, the matter is to be remanded to the appropriate authority to take a call. However, in view of the developments and also taking into consideration the observations made by this court in its order dated so and so, the order, one of the orders which I read just now, it is provided that if governing body assumes the role of disciplinary authority, the respondent number 5 should not be made a part of the same, and his place be taken by other official of equivalent rank. Now, my lord, despite this order, it is the respondent number 5 who has passed the order of termination. There, I was page 134 order, my lord. And just to show, my lord, how, my lord, malicious the intention of the respondents have been all throughout. Now, my lord, I was referring to these aspects, my lord, only to show how the petitioner was subjected to, my lord. In a sense, my lord, these are all mental torture, my lord. Now, the issue boils down to resignation. Am I clear, my lord? First, my lord, there were other litigations. Eventually, this honorable court held that disciplinary authority is the governing body, not respondent number 5. Therefore, he will not be a part of the decision-making process. Look, everything started because I was a victim of sexual assault, in sexual harassment in my lord workplace. So there was an ICC. ICC initially did not do anything, my lord. I had to write letters to the higher authorities and all. Then eventually ICC submitted a report finding substance in my allegation. Now, when the matter was placed before respondent number 5, he has passed an order saying that this is something it is not acceptable. Now, the Lordship knows after this POSH Act came into being, Central Civil Service rules were amended. Now, my lord, this inquiry report, initially the Supreme Court has taken the view that the inquiry report which is submitted by ICC, it is to be accepted as an inquiry report. And the proceeding has to start from that stage. Subsequently, my lord, by virtue of case law, my lord, now the situation is based on the report of the ICC. Now a show cause notice should be issued, and thereafter Rule 14 has to be followed of the CCS. Now, my lord, is there any provision or scope under the CCA Rule 1965 for a disciplinary authority to say that the charge, once having, my lord, inquiry report is there and he will not act on it? His duty is to proceed further in accordance with rules. Look, this is again I am submitting to show, my lord, the malafide intention. Now the issue boils down after, in spite of that, since they have again appointed me. Therefore, my lord, now I have submitted resignation. The resignation was not being accepted. I filed an IA. In the IA, Honorable Court passed the order. Now this order is passed, my lord, which your lordships will get at page 37 of the IA. Page 37 of the IA, my lord. This is 27/1/26. Refer to your letter dated 21. 21 is the letter at page number 32, my lord. It is intimated that you had been terminated from service as per decision of the governing body, which is competent disciplinary authority of the institute. You thereafter approached the Honorable High Court against the subject order of termination, and the matter is presently sub judice before the Honorable Gauhati High Court. Your application will be considered based on final judgment, disposal of your writ petition by the Honorable High Court. This is issued with the approval of the competent authority. My lord, this Honorable Court, on the contrary, gave them liberty to, my lord, consider my case. Order of this Honorable Court is at page 30, my lord. It starts at page 29. Mr. S.P. Sharma, learned counsel for the petitioner, submits that as per instruction received by him from the petitioner, she is willing to submit a resignation letter to the respondent authorities by tomorrow. It may be seen that challenge made in this writ petition is to the notice of termination issued to the petitioner by the respondent authorities. Having regard to the instruction received by the learned counsel for the petitioner, petitioner may submit her resignation letter to the respondent authorities, if so advised by tomorrow, and respondent authorities, upon receipt of the same, shall take a decision in the matter within a week. The decision to be taken by the respondent authorities on submission of such resignation letter may be produced before this court on the next date fixed. Now, when the Honorable Court has given liberty to the authority to consider my representation, now to reject my representation on the plea that writ petition is pending is perhaps, my lord, it is in very bad taste, my lord. It shows scant respect for the judicial authority of this Honorable Court. Now, what is the legal position on, my lord, this transfer of a resignation that we have annexed, my lord? If your lordship to kindly have this. the services of a temporary government servant shall be liable to termination at any time by notice in writing given either by the government servant to the appointing authority or by the appointing authority to the government servant. So it is both way, Lord. The period of such notice shall be 1 month, provided that service of any such government servant may be terminated forthwith by payment to him of a sum equivalent to the amount of his pay plus allowance for the period of notice and the same rate at which he was drawing them immediately before the termination of his service, or as the case may be, for period by which such notice fell short by 1 month. So, well, this is how. Now, well, Government of India has also issued
This is
some
applicable.
OMs.
This is applicable in this case.
Yes. Yes.
Section 5,
Yes.
Rule 5 of temporary service rules.
Yes.
Okay.
Now, my lord, there are certain circulars which we have annexed in our IA, my lord. If your lordship should kindly come to page 12, para 8 of the my lord IA.
Yes.
That the applicant begs to state that she was served with an impugn order letter dated so and so, informing that her resignation cannot be accepted and the same will only be considered after disposal of the present petition. The impugn action of the respondent are in violation of so and so rule, more particularly Rule 5.1, which states that the service of a temporary government employee shall be liable to termination at any time by a notice in writing given either by the government servant to the appointing authority or by the appointing authority to the government servant. B. The period of such notice shall be 1 month. In the instant case, the resignation letter of the applicant clearly mentions about her such resignation being applied under Rule 5.1, and as such, her resignation will be governed by government OM dated so and so, which further explains Rule 5.1 as when a temporary government servant submits a letter of resignation, a distinction should be drawn between a resignation letter of resignation purporting to be a notice of termination of sub-service and one which is not. Below a resignation would be a notice of termination within 5 years, and it could be on account of any other reason also. That is what is sought to be conveyed. A notice of termination given by temporary government servant under Rule 5.1 is something different from a mere letter of resignation submitted by him without any reference, direct or indirect, to the said rule. While the former is an exercise of right conferred by the statutory rules, enabling a temporary government servant to cease performance of his duty automatically on the expiry of the prescribed period of notice, the latter requires acceptance by competent authority in order to become effective. Therefore, my lord, from this contents of this Government of India OM dated 25/5/1966, what is clearly evident is resignations could be of two kinds. One kind is a notice of resignation within the meaning of 5.1, which is a statutory right, as distinct from a other resignations, my lord, which is not a right that I will apply, authority will consider, and only once it is approved, then only it can be said that the resignation has become effective. But in a resignation within the meaning of Rule 5.1 of the Temporary Services Rule, my lord, it's a statutory right. So when there is a right, my lord, there is a corresponding duty on the part of the employer to obey the statute and dispassionately follow it. Now here in this case, there are two infirmities. One, because they say that since the matter is pending, we'll take a call on your resignation only when the High Court matter is over. Whereas, my lord, the High Court itself on 21/26 gave a direction, not gave a direction, my lord, said that it will be open for you to accept the resignation. Secondly, my lord, Now, on the face of a statutory duty cast upon them, could they have behaved like this? Therefore, my humble submission is, my lord, though we came up with the plea of, my lord, that the termination order is bad on amongst other reasons, because of a judgment passed by the coordinate bench, respondent number 5 could not have passed that order. On that ground itself, this whole thing will go. Now, despite that, you gave me an appointment. And in the appointment letter, you do not refer to anything. Meaning thereby, virtually you have withdrawn that earlier termination notice. Now, even in your pleadings, you have never clarified anything. So therefore, my lord, it's a resignation within the meaning of 5(1), and there is no requirement of any acceptance of it. It is my statutory right. But I'm not a slave. I'm a citizen of a country which is governed by a constitution. On one hand, you are, look, this respondent number 5 and 6, they filed a criminal complaint against me. Lordship would be surprised to know the reason, because I submitted the email to the PO when I was harassed like anything. Now, finally, I'll just read one letter, my lord. If your lordship will kindly have page 574. Page 574. It is part of the affidavit in reply, my lord, filed by us. My lord, it starts at page number 559. It's a intra-departmental communication, my lord. No, inter. It is by one vice chancellor to, my lord, the president of the governing body. It is on 23rd of June 25. Has your lordship got it? At the outset, allow me to introduce myself. I am Professor.
Just a minute. You're reading from
Page 574.
of
Is the part of the affidavit in reply, which starts at page number 559.
what is this? 574?
Reply filed by us in the main unit. It's a letter dated 23rd of June 25.
Letter written by the petitioner,
No, letter written by, my lord, one of the member of the governing body,
Vice Chancellor,
vice chancellor. Yes.
to the
To the, my lord, president
President
of the governing body.
governing body.
Yes.
Okay.
At the outset, allow me to introduce myself. I am Professor R.M. Pan, Vice Chancellor of Assam University, Silchar, and the member of the institutional body, governing body, and academic council of AIMS Gauhati. It is with a heavy heart and deep concern that I write to draw the attention of the Honorable Secretary, President of the GB, and the esteemed members of the governing body to certain deeply disturbing events that unfolded during and after the extraordinary GB meeting held on June 19, 2025, convened to discuss the ongoing internal complaint committee proceeding as per the direction of the Honorable High Court. As per the court directive, Executive Director A.K. Puranik was not permitted to attend the meeting to ensure impartiality of the deliberation. I was entrusted with the responsibility of acting as the member secretary in his absence. After detailed discussion, it was unanimously felt that an unbiased legal opinion was required before reaching any conclusion, and the meeting was accordingly adjourned. However, what transpired the following day is both shocking and unacceptable. On the morning of June 20, Dr. Puranik made several urgent calls to me. When I answered at 10:10 a.m., he immediately launched into an aggressive and unprovoked tirade. Without any formal greeting, he shouted at me, accusing me of not supporting him during GB meeting. He made several derogatory and disrespectful remarks, including, I viewed the video recording of the GB, and out of the total discussion time, it was the additional secretary who dominated with 1 hour and 21 minutes of talk. You people just keep mum and did not support me. You all failed in the task entrusted to you. I must say you do not deserve to be in this committee. He continued in his demeaning manner, insulting all members, including Secretary and Additional Secretary, Health and Family Welfare, Government of India. Additionally, the meeting began, additional serious concern I would like to place on record. Before the meeting began, upon learning that Professor Manshi would be attending as a special invitee, Puranik became visibly agitated and instructed in front of other officials, the Deputy Director Administration, to prevent her participation. Accordingly, she was initially informed that she would not attend. It was only upon my insistence that she reluctantly called back. During the meeting, Deputy Director was observed leaving the room multiple times, presumably to consult Puranik, which raises serious questions about undue interference. I strongly urge that unedited video recording of the meeting be made accessible to all members to ensure full transparency. It is unclear how Puranik was able to access the video recording or whether he was formally authorized by GB President to review and analyze it before members were given access. I attempted to contact other GB members to check whether they too had been subjected to similar pressure or threat, but none responded, possibly out of fear, except for the Honorable President. Even before the meeting was formally concluded, Dr. Puranik had prepared his own version of the minute and attempted to have them signed. Upon learning that meeting was being adjourned, he became visibly furious. I strongly condemn the behavior of Executive Director, which in my view is unbecoming of someone holding such senior and responsible position. His conduct has raised serious apprehension about his ability to ensure justice and impartiality in the matter. In the light of the above, I humbly request the Honorable President of the governing body. So this is the person below, the Executive Director. Because this Honorable Court, a coordinate bench of this Honorable Court, my Lord, clearly observed that while dealing with the matter, he should not be a part of it. He was sitting in the outside the room, and this Deputy Director was, my Lord, moving like a shuttlecock time and again. So therefore, my humble submission is, my Lord. Therefore, my humble submission is, my Lord, I am proceeding on the basis, of course, that initial termination letter has lost its efficacy. They are not insisting on it. Therefore, they have come up with a new appointment. Now, they having appointed me, now I have resigned from the post. Now, either your lordships again direct them to consider it, or lordship passes an order on my resignation, because it is a right. There is no requirement of any lord, as the termination notice takes effect from their perspective. Similarly, my termination also takes effect in accordance with law. In other words, it will be a legal fiction, my lord. And it is the duty of the constitutional courts to give effect to legal fiction whenever it is created by a statute. At the end of the 1 month period, it becomes effective. So they cannot withhold it on the ground that matter is pending, because it is the same High Court where the matter is pending has observed that you may take a call on it.
Mr. Chaudhary.
Yes.
So what I understand
Yes.
is that there are two types of notice.
Yes.
Temporary service 5.1 and the others
Any-
normal or any other ground. 5.1 is a statutory in nature. That the moment the time is given by either of parties, it takes effect. The other one, of course, the requirement is acceptance.
It is something like a.
Since your notice was under 5.1, so on the expiry of that period,
Yes.
it has become effective.
Yes. That's
So
my
for that reason, irrespective of me being posted here or there,
Yes, yes,
I am deemed to be resigned
yes,
from that post.
yes,
So if there is accepted, matter ends there.
yes. That is the point.
Hmm.
Because they cannot, because your order is also to the same effect. When you terminated me, you have taken recourse to the same very rule. And same very rule also authorizes me to resort to this type of action.
Their notice otherwise was what? Let us see what is the notice regarding 134.
134.
How has it been worded?
Yes.
134.
It's an innocuous order, below.
134 is in the, I think, main. 134 main.
In pursuance of terms and conditions mentioned in the appointment letter referred above, I hereby on behalf of the competent authority give notice to Nisha Tuteza presently serving on probation that she has been found unsuitable for confirmation while being on probation and her services shall stand terminated, simpliciter with effect from 1/9/23.
So initially, you had come against this.
Yes. Now, despite this, when they have given me a posting order, so my lord, they say this has lost its efficacy. So now the issue boils down to only resignation part. That is what I comprehend, subject to what my learned friend says.
Okay, let me hear the other side.
Yes. My lord, sorry, one second, please. My lord, that I have given that compilation, my lord.
Which compilation?
No, sorry, one rules, copy of the rules.
Oh, yes, this CCS rules.
Yes, if your lordship will kindly come to page 2170.
Hmm.
2170. There is a heading, reasons should not be mentioned in termination order. Page 2170. Reasons should not be mentioned in the termination order. Has your lordship?
Yes, yes.
Yes. Then down below that 22 June 1956.
Hmm.
Then below the later portion which I quoted in para 12. Until page 2171. So we have quoted from this.
Yes.
Hmm. I once again draw your attention to page number 134 of the declaration. That is the termination order.
Yes.
Lordship, if we talk the signature part of this,
Just a minute. Huh?
Yes.
What is your good name?
full day.
Mukul Dev.
Yes, sir, Lord.
DEV.
DEV, Your Lord.
DEV, okay.
DEV.
You are for the respondent.
And for the respondent number 2, 3, 4. And 5. 5, 5, 2, 3, 4.
2, 3, 4.
Yes, sir.
Okay. 134, yes.
Lordship. Firstly, I will give you a little background.
Hmm.
A minor workplace disagreement in between two qualified doctors
Hmm.
was given the
Hmm.
color of sexual harassment at workplace.
Hmm.
When the ICC started,
Hmm.
all kind of intimidation was carried out by the complainant by writing to the President of India, to the PMO, to CP Gram, I don't know where all,
Hmm.
so as to influence that ICC.
Hmm.
The ICC, as per us, got intimidated and passed an order, whatsoever order it was, right or wrong. That order was to be accepted or not to be accepted by the governing body. Finally, governing body passed some order dissenting from whatever the ICC findings were.
Hmm.
Now, there is a clear-cut provision in section 18 of POSH Act, which says anybody who feels aggrieved by the order of the ICC can challenge the same through an appeal. There is no appeal which has been made by the complainant against that order.
Hmm.
That is my one
What's that?
point out. Section 18 of the very
Yes, please.
18 appeal. Any person aggrieved from the recommendations made under subsection 2 of section 13 or under clause 1 or clause 2 of subsection 3 of section 13 or subsection 1 or subsection 2 of section 14 or section 17 or non-implementation of such recommendations may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules applicable to the said person, or where no such service rules exist, without prejudice to provisions contained in any other law for the time being in force, the person aggrieved may prefer an appeal in such manner as may be prescribed. Lordship, there was no appeal which was ever filed against that ICC findings and the
What-
governing body.
Yes, what does it refer to? Court or tribunal? What is this? Which court?
It says to court or tribunal in accordance with the provisions of the service rules.
Yes, what does it connote to? Court means what? Does it include the High Court?
It may, or under CCS rules, if there is some other appealate authority, she could have filed an appeal there.
Okay.
Till date, there is no challenge to that ICC findings or the governing body dissenting. So this is as far as that ICC. Otherwise, she could have gone to district court even challenging the said findings.
Yes, then?
Now, Lordship, I come to the second part. Now I draw your kind attention, Your Lordship, to page number 134, which is the termination letter, which was issued on 22nd of August 25.
Hmm.
Lordship, if we see the signatory part, it says Dr. Ashok Purani, Executive Director, AIMS Gauhati. In bracket, it is most important, for and on behalf of the governing body. Your Lordship, he is not doing anything at his own. It is on the part of the governing body that he is passing such an order. Lordship, I must add here itself, for the benefit of everybody here. This particular person, Dr. Ashok Purani, has put in 4 decades of service in the army. He was a qualified doctor and a distinguished doctor of the Indian Army. He retired from there and took up the job here. He is a retired colonel from the army and he is a pensioner. Lordship, he has passed any order on the basis of the governing body directions. It was not his order. In spite of this, and it was countersigned also by
No,
the chair.
one minute. This Dr. Ashok Puranik is the person against whom the complaint was made.
No.
Who is that?
6. Against
6.
respondent number 6, the complaint was.
Oh, 6. Jai Shankar.
Jason.
Okay.
Dr. Jason.
Okay.
It is not under.
And why is Puranik made a party by name? Otherwise?
That is not.
Puranic, because he and Jayashankar has conspired to without false prejudice to the petition.
I see.
I mean, not me, this is the Honorable Gauhati High Court has observed in that order, which I have read.
Okay.
Lordship,
Malicious
the
action.
bench of this High Court observed that he could not have passed an order since an allegation has been made against him, and that governing body which while it was taking decision, he should not have been made part of it. So he was excluded. The letter which my learned friend has read later on, at page number 500 and something, part of his counter affidavit, it clearly shows that again a meeting was held in which he was not the part of it. They are making an allegation that the deputy director was going inside and outside time and again, and he was getting the directions from Colonel Puranik. These are all insinuations, apprehensions, surmises, conjectures. There is no written evidence which can substantiate this allegation of theirs that he was getting the instruction from Colonel Ashok Purani. Now, Your Lordship, I am coming to the second point of that. That since she has been given a further appointment, so her termination order stands cancelled and she continues and her probation period continues. Lordship, when such allegations have been made by one of the colleagues, that is Dr. Jayashankar, wherein she has made allegations of sexual harassment, which rightly or wrongly has not been found to be substantiated. Now, she being from the Department of Pediatrics, she has been posted to the Department of Neonatal Care. Under a lady, it has been mentioned very clearly there that she is under Dr. Saraswati. It is not understood why respondent number 5, Colonel Ashok Puranik, is being made a target. Neither he was a person who was targeted in the sexual harassment case, nor anything else, just because this particular gentleman, he was doing his duty as assigned to him, a constitutional duty. He is being made a party because he is a signatory. However, Lordship, we must also note that at page number 134, there is a counter signature of the chairman of the governing body. It is not at his own that he has been passing such kind of an order. Now, Your Lordship, my learned friend is accepting that yes, they want to leave, they want to resign. Lordship, the resignation could have been considered had it not been conditional, the kind of allegations again on the, I just read out the resignation letter. The kind of allegations again has been made in the resignation when we are saying that it is a termination simpliciter. Our word clearly says on page number 134 that her services shall terminated simpliciter termination. We are not making any allegation against her. And on page 41 of the page 31 of the IA, Lordship, I draw your kind attention. Page 31, the resignation letter which she has submitted subsequently, it is at page 31 of the IA.
Yes, that I've seen. It was read out.
Yes, Lord. No.
Your point is that your termination was simpliciter, whereas the resignation said so many reasons and certain allegations were made.
Other side also. Let her give a resignation letter, we will place it in front of the governing body. Dr. Ashok Puranik is no authority to take any decision on this. We'll place that resignation letter if it is a resignation simpliciter which she is giving, not with all these kind of loaded words which she is using in this. He gives that, we will again consider as a resignation, there is a problem. We are not having any objection to that. But then this petition, which time and again is coming up, IAs are being filed, all kind of allegations are being made. These will go away. That governing body will take the decision on the resignation. If my learned friend is ready to accept that, we are ready to go a step further and give a wide burial to this controversy. Time and again, somebody or the else is being targeted. Respondent number 5 is being targeted. What for? She is a probationer. Her services were there for 2 years. He extended that on the orders of this honorable High Court. What my clients have committed? We have tried to adjust her in every possible manner. She has been given a job for which she is being paid.
So, Milan, once again, as suggested by my learned friend, simple resignation letter, like we can give it tomorrow. Let them accept it.
Lordship, we place that resignation letter, as I said, in front of a governing body.
Who's to decide? Governing body.
Yes, Your Lordship, governing body. We want to give a quite burial.
We will be doing it again, having regard to what has fallen from my learned friend. That it should not be, loaded with any other allegations and all. We'll simply, in terms of I1, we are giving it 10.
Resignation simpliciter.
Yes.
Resignation
You're ready to accept that and take a consideration and place it before the GB. And
Keep the matter pending.
if that is
the matter should be disposed of.
if that is the case, then it becomes.
Lordship, in case she is agreeable with the order which will be passed subsequently by the governing body, whatever it may be, they are at liberty to file another IA.
No.
Once
it is closed, lot many complications may arise. If you are doing it honestly, bona fide, well, we'll wait for 10 days.
Lordship, I am under instructions to say so. What I am saying here, it is not at my own that I am making some commitment.
No, you must be also aware of the fact that in the last date also, the court also had given liberty that you take a call on this. But then you reply saying that since the matter is sub judice, we are not doing anything now.
Lordship, we said so because the kind of words which have been used in the
No, that is why, see, that is the history now.
Yes, sir.
As on today,
Yes,
your suggestion is that if she gives a resignation simpliciter, we are ready to place it before the governing body.
Yes,
do that.
we are ready to do that.
And within a time frame, you give us the result and we accordingly take a decision. Those the matter.
Yes.
That'll be fair to everyone. I don't think, see, all these things, if I may say so, of course, many human elements are there, you see.
Yes, I
Once you're pinched somewhere, like this way or that way, you try to, like take things to some other level. It's no purpose is served ultimately. So, if your counsels are fair enough, you get one simpliciter resignation letter within a time frame, and then you also take a call within a time frame.
Yes.
Post this matter on a particular date and tell us the result.
Yes. That will close it. With your permission, not in my case of here. She is being paid her salary. We are unable to make or use her services. the patient care is getting adversely affected. We also want that we should move on from this controversy.
So let us move on then.
Yes, Your Worship.
Okay, let us, please write hard Mr. Ken Chowdhury, Learned CD Counsel, assisted by Mr. S.P. Sharma for the petitioner oblique applicant. So this also heard Mr.
Dave.
Mukul Dev, Learned Counsel for respondent numbers 2, 3, and 4, and D.S. Bhattacharya, Learned Counsel appearing for respondent number 5. I have also heard R.B. Fukan for respondent number 6. And Miss A. Gayan, Learned CGC, A. Gayan, CGC for respondent number 4. 4. Then you will be for 2 and 3.
120. Hold on. 237.
Who is 1? Who is 1? 1 and 4. Miss A. Gayan for 1 and 4. Mr. Dev is for 2 and 3 then?
Yes, go ahead.
Okay, okay.
I am for 2, 3, and 7, Your Worship.
7 is also there?
Yes,
Okay.
7 is also there.
Okay, 2, 3, and 7. By filing this writ petition, the petitioner has challenged the notice of termination of our services served to her on 22/8/2025 by the Executive Director, AIMS Gauhati, for and on behalf of the governing body. This court, while issuing notice on 21/2026, no, sorry, that's not the date, on 1/9/2025, had passed an interim order to the effect that the impugned notice of termination would remain suspended till the next returnable date. Stopped. The said interim order subsists as on today.
Yes, Your
Till date. Till date. So in the meantime, the petitioner has filed the interlocutory application bracket civil number 260 of 2026, by which she has challenged the order of posting dated 27/1/2026, as well as the letter of rejection of our application for resignation dated 27/1/2026. Stop. Today, the rival parties have made their respective submissions in brief. And during the course of the submission, Mr. Mukul Dev, Learned Counsel appearing for respondent numbers 2, 3, and 7, on instruction submit that if the petitioner is agreeable to submit an application for resignation simpliciter without making any reference to the alleged atrocities committed to her, as was mentioned in her notice of resignation of service dated 21/1/2026, comma, the respondent authorities concerned are agreeable to consider our application and place the same before the governing body for its consideration. Stop. Mr. K.N. Chaudhary, learned senior counsel, appearing for the petitioner, stroke applicant, submits that if that be the case, the petitioner is willing to submit her letter of resignation simplicity by tomorrow. That is, give the date, 1st of April. April Fool. April Fool, huh? 1st of. So, considering the submissions made by the parties, this court is of the view that an opportunity be created as suggested by them. Accordingly, the petitioner shall submit her resignation simpliciter by 1/4/2026. Before whom?
Governing body or the,
No, give me a particular name,
governing body.
respondent number before the governing body,
Seven.
bracket respondent number 7. And the respondent number 7, upon receipt of the same, shall consider and take a decision within 15 days.
Okay.
15 days of receipt of the same. List the matter again on when? 6/5.
Can I, she's not working, she's on unauthorized absence of leave, since law.
Let us not bring in all this.
No, I have to bring it.
Sorry. When I, instead of 1st April, possible kindly make it 2nd. For example, if we cannot communicate or something.
Yes.
2nd.
We don't have any problem.
It sounds better, huh? Second April.
Join back.
So you take a decision within
Yes.
within 1 week, then 10 days, 1 week
Also can we call it on?
Actually, governing body has to be collected.
collected. So how difficult is it to collect? Virtual? You don't do it virtually?
No, we
Do
don't.
it virtually?
So many documents are there, so many things are there.
No,
They are
this system
comfortable.
is taken virtually. Virtually, they can nowadays without when technology is available.
I would still request for 15 days. That's I leave it to your order.
All right. We'll go by your request since you had offered 15 days. Okay.
She joined. She has not something to do. She's not.
She's working hours.
She's on unauthorized absence leave.
Oh, she's working, don't, she's already frightened below. Let me tell you, below,
It doesn't mean that she will not come.
she's
to the
already,
office.
below, she's a lady below,
She should come
kindly
to the office.
appreciate. Lord, instead of 6th of May, Lordship can respond this matter, we are reopening on 2/0. Lordships can have it on 27th April.
27.
Cool, master. Okay. List on 20. Okay, Mr. Dev. Monday. List on 27, 2026. The respondents concerned shall inform the court about the outcome of the consideration by the government body. That is.
Keep your.
What grateful to you, Lord.
Interim order may continue then. Is an interim order.
What was the interim order?
For what, when she being placed, she's in the working method.
She's not working.
She's not. There's an IA that we have filed where our leave and application, everything is there. So this substance of his argument is not.
All right, needless to say, the interim order passed earlier shall continue till the next date of listing.
Lordship, then in that case, if we accept the resignation,
Huh?
15 days, then will she still continue this?
No, then this will get disposed of.
No, there was an interim order passed, isn't it? What is the harm in continuing
My
that?
submission is
Ah.
next. Once the resignation is accepted, then where's the point?
On 27th of April, the matter will be over and by that time she'll leave.
No, if we take the decision, she can, we can relieve her, the day the governing body takes the decision, we can relieve her within 3-4 days.
Yes, till then.
Then we make that observation then.
Yes.
Interim order shall continue till the date a decision is taken by the governing body. Right.
My lord, if they somehow does not accept my resignation, in that case, there will be, that's why my lord may take it on next returnable date on 27. Let them put the decision here. If they don't accept it.
No, automatically, if their resignation is not accepted, we will continue.
If they don't, then I'll be again hanging. I'll be hanging. So that is why my lord may keep the next returnable date. It's a judicial order, and by then everything will be clear. If my resignation is also accepted, it has to come from a judicial order, my lord. So let it be till next returnable date as it has been.
Lordship, if we take the decision, she is not working, I am again submitting. Lordship, she is not coming to the office. It is a loss to the exchequer. The patients take care every day is getting adversely affected. In case we accept her resignation on a particular day, let's say on 10th, then she can be released and we can appoint somebody else on probation.
My lord may see my.
No, but the thing is that we have fixed a date.
Yes.
Let it come up with the next date. Interim order continue till the next date. That'll be better. And the remaining matters, I think there's no time. Mr. Who was there? Mr. Benudhar was there, but unfortunately we cannot do that. It's time to rise. So we have a date if you want.
Vacation might release that.
Before vacation is not possible, madam, because this 2 weeks, I mean, the last 10 days will be for motion. That's why. Court master will give a date.
Yes. Some of the respondents in their case, your lordship, some of my petitioner is retiring, your lordship.
When is he retiring? During the vacation?
Yes, your lordship.
I think after vacation. Don't let her retire during vacation. Retire after vacation. 28-4. This is item number 28-29. Yes. Due to paucity of time, matter could not be taken up today. In view of above and as paid for, list the matter on 28-4 for hearing.